Hey, what's up, guys? Welcome to Lawsplaining the Interwebs. Never mind the headphones and my muted guest. He's resolving a technical difficulty, and he'll join up in just a second. I am your host, Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. My guest will be with me in a moment, but today is an interesting day. Today's an interesting day. We've got a lot to talk about. There's a lot of emotionally charged activity going on, and you're all set. You're all set. Okay. Let me welcome my guest to the show. With me today, of course, is Mr. Ty Beard. How are you, sir?
Hey, man, I'm doing great.
Good.
I'm doing great.
Good.
How are you?
I'm fine. I'm annoyed at some things. There are things I'm annoyed with, but
wait for the Port Aransas ferry for an hour and a half when you're a mile away from the pavilion where all the food is, and then you can talk to me about it.
I hate that boat. I hate it because
don't get me started.
build a drawbridge.
No, they don't want to. They don't want to because it would cause too much traffic to come pouring in, and it would change the character of the town. The problem is they're building the port here. They're going to have to. But yeah, you haven't lived until you've, literally an hour from the pavilion. I mean, a mile from the pavilion where all the food is. I swear I could smell the food in my truck.
Yeah. Yeah, I waited at for that stupid boat for 2.5 hours the last time I had a family reunion down there. And I wanted to excavate the bones of Genghis Khan to fix the problem.
Yeah. Well, what you do is you go through Corpus Christi and take the bridge there. The problem is I was sold out by Waze, the app that all the crazy kids are using. My parents are like, Dad, God's sakes, join the 21st century. Stop using Google Maps. And I'm like, but I thought Google Maps was cool. No, silly father.
I'm not sold on Waze, especially if it ever tells you to take that ferry.
No kidding. I mean, there should have been some giant flashing light warning. There's an hour and a half ferry stop. I knew something was up though. We're driving along, and I'm like, can't wait to get there and get out on the boat and da-da. And I look down, and the thing says, 10 miles or 15 miles, whatever it was, and an hour and a half ETA. And I went, what the hell? It must be, Of course, I reached out, I hit it, and Brittany goes, Dad, hitting your phone doesn't actually fix it.
Yeah. So we're lost in deep Texas lore here. Real quick.
Yeah, sorry, guys. Yeah.
Real quick, there's this place near Corpus Christi called Port Aransas, Texas. And there's this, it's not on an island, but maybe it is on an island. It's on a
intercoastal water, isn't it? Whatever.
You glitched out a lot there. But the long and short is the bay comes in, and you have to go across the water, and there's a series of ferry boats that you can take, or you can drive 48 minutes over to Corpus Christi, cross the bridge, and come back. And it's quicker often to do that than to wait for the ferry boat to go literally a mile. It's a dumb place.
It would have been infinitely quicker today.
Yeah.
And there's another weird geographical thing there too, right? So the ferry boat landing is here, and you got this long highway, like 10 miles or something. It's a long way. There are no gas stations.
Yeah.
Anywhere along that thing. So you're sitting there stopped in traffic, for hours, and you start looking down and you go, wait a minute, I filled up in Tyler. That was 7 hours ago. Crap. And you look down and your gas gauge is like pegged at you. Please no. So
okay.
We had that excitement,
Yeah. Okay, so you're down on the coast then.
Yeah. I'm at a charity fishing tournament, the San Antonio Pipeliners Association's second annual. One of my clients threatened to fire me if I didn't come down and let him feed me full of actually really good bourbon. He called me and said, "Now, what kind of bourbon do you like?" I said, "Jack Daniels." He goes, "No, really, what kind of bourbon do you like?" And I said,
"Yeah,
Maker's Mark."
What did he give you?
Maker's Mark, and some other stuff that I don't know the name of, but you'd know.
All right. Well, I figured you would have actually stopped by a metalsmith to grind out the edge on the wakizashi and prepare yourself for seppuku.
Right. Yeah. You don't want to do that with a dull wakizashi, because it gets hung up. No, not a chance.
Yeah. Okay, so let's kind of jump into this. Here's how I'm planning to do the stream. I'm going to interview you for a while. I know you can't talk too much about the case with specifics, but
we're gonna have to be up at 5:30.
So we're gonna talk a little bit. We're gonna address some questions from the chat before you leave, and then after you leave, I'm gonna read through the ruling and I will give my less filtered opinion on what is going on and all of that stuff. But so let's kind of get right into it, because people, I think, really want to hear this stuff. So what I guess in a nutshell, what happened today? The big question I keep seeing is, did Vic lose? No,
of course not. What happened today is the most likely event that we expected to happen after the hearing. If there were several possibilities, and you covered that on your show last night, I think.
Right, I did. But I like to hear it from you. So
sure. Obviously, anything can happen, but the biggest problem the reason that certainly none of us fell out of our chair and went, "Oh my God," is that if the court believes that it ran that hearing right and that it applied the law properly, then there is no way they could leave the other defendants in under defamation, because the theory that lets Markey off the hook would also let the rest of them. So the court would have either had to be inconsistent, which would be an appealable error, or they would have to backtrack. And courts have been known to do that, but it's not likely. So certainly, when weeks ago when we were wargaming out what would happen and all this kind of stuff, it was clearly the most likely scenario is that he poured us out completely. It also had the effect. I mean, you look at this through the court's eyes, and again, I'm not criticizing the court. I'm not allowed to do that. But I'm trying to talk about this at kind of a strategy level. You look at this through the court's eyes. From the court's perspective, there's efficiency in just pouring the whole thing out. One of the irritating things about TCPA is it's asymmetrical. There's if he denies the defense motions, they get an interlocutory appeal. If he grants, we don't. But of course, if the defendant does if he does both, now you've got the defendants with their interlocutory appeals. There's a strong argument, yet it's not real well tested that, if the defendants have an interlocutory appeal, then the plaintiffs should be able to cross appeal too. So it's messy. I mean, certainly I think the legislative intent for the anti-SLAPP statute was that it apply, kind of be an all or nothing thing. Now, the problem with that interpretation is it very clearly says that you'll consider each cause of action separately. But it really doesn't work well at all when you have a messy partial denial and partial granting. So, I mean, here's the thing. The day after the hearing, as we began to project out how this was going to play out, in 2 months we were going to be in the Court of Appeals, no matter what, right?
Right.
So looks like in 2 months we'll be in the Court of Appeals. I don't know,
Yeah, that's.
I don't know what the big oh my God, yay, or the end is near.
So
all that's about.
Are you confirming then an appeal?
I can't, because actually I've not been able to get a hold of my client because we've been playing phone tag, and the phone service through South Central Texas is not all it could be. So technically no, but do I look like we're not going to appeal?
Yeah. Well, I mean, and I think that's something for people to understand.
That'll probably be a clarification on that tomorrow, but certainly no one should bet the rent money against it.
Right. And what many people seem to be ignoring, and what's very interesting for for several very accomplished lawyers to be ignoring is that appeals are part of the process. A win is never a win, and a loss is not a loss until all of the appeals are complete or the time has expired on them. You even if you win, you sit there and wonder, like, okay, are they going to take this to appeal? Now, sometimes you have a reasonably good idea on the success of the appeal and the financial situation of the parties, but I would say in this, from what I've seen, this case looks ripe for an appeal. It really.
I think as I said, I wouldn't bet the rent money against there being an appeal.
Right.
As you know, I have to be careful. We're not allowed to criticize the court, and I'm not criticizing the court. I'm talking in generalities.
Sure.
But no, the appeals are part of the system. We put a lot of responsibility in the hands of one person in the form of a judge. Our legal system is designed to be operated by human beings, and human beings make mistakes. So we have a process to deal with that. The process is somewhat deferential to the trial court because otherwise everything would be appealed all the time, without merit. Not too worried about, in this case, I don't know if deference is going to be that big a deal. Who knows? But, we have appeals courts have 3 judges, right? At least this one will. The odds are that one judge might have say a 20% chance of getting it wrong. Well, 3 judges, all 3 of them getting it wrong, the odds are 20% of 20% of 20%, very small percentage. So it's a very well-designed system. Now, I have seen appeals court decisions where I went, my God, what were they thinking?
Right.
But generally speaking, playing the odds, the appeals court they get it right a lot more frequently than they get it wrong. You just disappeared.
I did? No, I'm still here. You disappeared.
Okay.
Well, I mean, you didn't. I'm lying. That was a joke. I was just saying you disappeared. You're very much still here. Sorry, that was my reaction.
Okay. I can't see your face. All I can see is the green RL thingy.
Well, that's weird. I blame you for that. It should be broadcasting me, but I don't know that I can continue without seeing your face, Nick. I mean, let me see here. It's really
here we go.
It's just me flipping you off constantly.
Oh, is that what that is?
That's what's going on. Yeah.
Okay. And of course, I'm doing this on my iPad, which sadly is not idiot proof. Let me see what this does. Okay, that doesn't do it.
No, that changed the camera to the other side.
To the other side of the iPad, yeah.
Did this do it?
Nope. You're just you're green and round just like before. Let me see. Here's something that looks like I could push. No?
Yeah, that's your camera. I don't think you can change. It might just be how it's handling the data, making sure that you're.
Oh, you know what? Yeah, I mean, I'm using whatever internet exists in this 3-story vacation home. So
right.
So it may be the default thing. By the way, you can tell I'm in Port Aransas because I actually have this is the decor.
Yeah.
And I think you can see the stuff behind me.
Right. Well, let's just try and weather through.
Sure.
Because I don't know if we can get it. And is there anything you wanted to say before we get to the questions?
Oh, not really. I mean, I find it. I got to say, I find it. I don't know if bemusing is the right word, but this idea that this thing is over is somewhat optimistic, I would say, on the part of the other side. Look, the defense won around, no question. I mean, they won around, but this thing, we are a long way from this thing being over, and assuming my client authorizes the appeal.
Right.
Got to say that.
Yeah, and it's always up to the client, but man, this one looks like the kind of case that you definitely should appeal, but we'll see. We'll have to see.
Yeah. I mean, it'll be clear when we file our appeal brief. It'll be very clear where we disagree with the trial court on how it did. We do disagree with the trial court. That comes as a shock to virtually no one, I would hope. I would say
that's it's important to distinguish that disagreement with the trial court isn't criticism of the trial court. That's part of the process.
No, that's right.
So if you believe that that something was handled inappropriately, or the law was misapplied, I guess is the more appropriate way to say it, then you appeal it, and that necessarily involves some that necessarily involves disagreement with the court.
Yeah, and I've always been a big fan of our legal system. I've had things go my way when they shouldn't have, and I've had things not go my way when they should have. That's never shaken my faith in our system, because while it's imperfect, it's the best around. You know, you can't have 3 judges hear every case, right? That's not practical. There's just not enough money available to do that. So it's a filtering system. You filter through the trial court first, and gosh, now
you are a robot. Hold on just a second. Your internet just Hold on. You're coming back.
You're back.
Yeah, you disappeared. Okay. That was your fault.
Okay. Well,
I'm just kidding. It was your internet.
You know what? I'm going to try something. If I disappear, I guess I'll just reclip.
You could always reconnect to the Hangout.
Yeah, give me 1 second. Let's see here.
Okay.
Oh, okay, there it is. Right. For some reason, okay, they've got Wi-Fi here, and for some reason it's connecting up and not asking me for the password. But never mind. Okay, I think I know the answer to that. I logged on with my iPhone, and I think that automatically logs me onto this. Anyways, yeah.
Okay.
Brittany, do the internet.
Yes. Yes. All right. Well, let's.
So anyway, what I was saying was, I'm a big fan of our system. You know. And it works better than anything else I can come up with. It gets it right more often than not. You know?
Sure. So. Your audio's way out of sync. Just a second. God. Okay, now talk.
I am talking.
Oh, that is so annoying.
Oh God! Why don't I reconnect and see if that does? I'm sorry. That's just, I've got the internet I got.
That's how vacation Wi-Fi always works.
Yeah.
All right, go ahead and reconnect.
Let's crack on through it. Okay, I'll shut this down and reconnect.
Okay, while we wait for Ty to come back, I'll because man, that got really frustrating. We'll go ahead and take a look at some of these chats I can read without Ty present.
Hey,
of course,
I'm back.
You're back. Oh, never mind. Well, we'll read them with you.
And all
present.
Of a sudden, you're like in high definition. You were
Sometimes you just need to reconnect to the Hangout.
Disappeared.
No, Hello? Skynet. The Skynet is taking over. Well, let's just look. I
should hurry up.
I think we're at a point where we're just going to have to try and get through it, and I think your internet will either catch up or it won't. Okay, so Nunya Biz says, unpopular opinion, Lemoyne played this case the best. He knew Chup's real motivation, an easy day at work. By being obtuse, difficult, and annoying, he wore down the judge's limited patience. That's where Vic's side got played. So there's that theory. Come on, guys. Marchie's Fat Dirty Crack says, is it possible that Chup was biased towards the defendants due to them being women? Also, was it possible he was afraid of being crucified by the media by people like Sharon Grigsby?
I don't believe so. I truly don't.
Yeah.
And if the court is found by the appeals court to have erred, it's an honest mistake, in my opinion.
Right. You know? And everyone else is free to form their own opinion on that.
Absolutely.
Right. But, I mean, the reality is the appeals court is concerned with whether the law is applied properly or not. That's the extent of their concern. There are some cases where you might be appealing based on some sort of impropriety on the judge's part, but there's no evidence of that at this point. So it's silly to sort of speculate.
No, I mean, it's like in a football game, right? When the refs blow a call, you know, what are you going to argue that the refs don't like your team? I mean, come on. Now, that does happen with the Dallas Cowboys, but that's a different But everybody knows that. So,
But I will add something for people to think about, and one of the things you kind of touched on this earlier is that it's one judge who is a person, and people are susceptible to all sorts of things, including concern with personal image. If you want to look at a judge who might have been concerned with personal image, look at how Chief Justice Roberts wrote the Obamacare decision. And try and noodle through it from a legal perspective, and you'll be baffled. But noodle through it from the perspective of this is the legacy of my court, and you won't be as surprised. So,
right,
y'all can.
that's fair. I mean, I think that's actually an accurate assessment of that case. And yeah, I mean, look, hypothetically, if I was a trial court judge and I felt that I had ruled the correct way, well, I would run it through. I mean, and if I didn't think I'd acted correctly, I would hope that I would change myself. But trial courts don't do that very often,
right?
And
and there's an appeals court for a reason, and the trial courts know that too.
Yeah, so. The trial court judge can say, I mean, I've never been a trial court judge, but I could easily see myself on the bench saying, "No, I think I got it right." And if I didn't, let them tell me I'm wrong.
Right.
That's fine. I mean, nothing sinister about that.
DOG Beerus says, if an appellate court grants an appeal, does the case automatically go back to Judge Chupp?
Yes. Well, yeah. I mean, I was noodling through this earlier this afternoon. Our appeal would be, assuming we will appeal the granting of all those motions. The Court of Appeals, the remedy that the Court of Appeals would give us would be to overturn the granting of those motions. Now, it could overturn them and say, "Sorry, trial court, you were completely wrong," if they found our way. Or they could send it back and say, "Trial court, you didn't do it right because of this, that, or the other thing, so do it right this time." So it depends a lot on, and just like everything else in the law, we'll plead multiple theories, right? We'll say, well, the trial court erred for this reason, but even if they didn't err for this reason, they erred for that reason, and yada yada yada. So it could be, but yeah, I mean, you're going to wind up a trial court getting something wrong is not grounds for accusing a judge,
right?
That doesn't work that way.
Right. So short answer to that question is it depends on how the trial court handles it. They may actually rule on the TCPA, or they may remand back to Judge Chupp with instructions on how to do something differently, or they could say he did it right. Those are sort of the options here.
Yeah. Well, yeah. I mean, yeah, we're assuming that they see it our way.
Right. Let's see. The next part of that question was, what happens if he dismisses everything again? Well, then you can either appeal it again if you
appeal again if you think he's got it wrong.
Right. Or it says, is this case over, or is there a higher court that can be appealed to? I mean, in theory, you could petition. Yeah, you get to appeal to the appeals court, and they can. Do they have the option to reject the appeal? I mean, they would just rule on it.
No. Right. No, they have to take it. The Texas Supreme Court, of course,
right. You have to petition.
And so they. Who knows? I mean, they like issues that are controversial, i.e., the circuits have ruled differently. They are a mess procedurally.
Interestingly,
the Supreme Court to look at it, you're
glitching out, so I'm going to make a point while your internet comes back. But interestingly, there are issues in this case where that are appeal points that are split between the circuits and how they deal with them. So I'm not saying that this case will or even should go to the Supreme Court, but there is a possibility that either Vic or the defendants, depending on how the appeals court rules, could escalate it to that.
Well. Point. I mean, I'm going to hypothesize for a moment. On a case like this, if you appealed and you lost the appeal, why on earth wouldn't you at least try to give the Texas Supreme Court a crack at it. I mean, that's
right. Now the Supreme Court,
that would be the expected outcome.
They rarely handle interlocutory style
correct
appeals. It's typically
this.
Go ahead.
Yeah, this is not interlocutory though.
No, it's not. But I'm saying if the appeals court were to say remand it back to CHUP, then appealing that. Well, no, that it would be.
I got you.
It'd be very
depends
interesting.
on how you're back into that TCPA morass of trying to figure out everything.
Mm-hmm.
It's a.
Well, we'll just have to see.
It's a mess.
From Eggman says,
like I said the day of the hearing, no one should be spiking the football.
Right.
I have always found that being gracious in victory is the safest play, especially in the law, because, like you said earlier, it ain't over till it's over, and
right.
People do tend to they tend to carry a grudge if you act like a. If you act like a jerk just when you're up. I'm not saying anyone is in this case. I'm saying simply.
Right. Speaking in the hypothetical.
It's unwise to gloat. It's unwise to gloat until the Texas Supreme Court says we are not handling this.
Right.
Then you can gloat. Then you can gloat.
The Pie Baker says, Mr. Beard, if a hypothetical judge is going to show up to hearings hungover from trying to forget a sexual bribe from a bit sorry. It got changed. Trying to forget a sexual bribe from a defendant, then you need to show up to court with enough blood in your alcohol system to take down a blue-haired orca. Here, take this.
Well, that's a lot to unpack.
Yeah. No, it wasn't a question. It was just a statement. So there you go.
Noted. Noted.
Matt the Beast says, I don't get why people are nearly as mad at Ty as they are. If they're told that they're playing soccer, they might be a bit surprised when the referee says their opponent gets 50 yards closer to the goal because they traveled with the tennis ball.
Oh, they're mad at me because I'm responsible. I mean, it's my fault.
Wait a minute. Are you saying that as lead counsel, you bear responsibility for what happens?
Who else would? Of course I am. Well, my people did their jobs perfectly. So if they did their jobs perfectly, then, of course it's my fault.
Yeah. Well, I was going to blame Mark Zuckerberg, but, strange choice.
Yeah. This is the old Harry Truman thing. The buck stops here. And I've never, ever blamed someone else for a failure. And, right now it looks like a failure. But I just wouldn't be dancing in the end zone yet if I were the other side.
Right. From Eggman says, it's worrying that people want their fellow countrymen as well as kith and kin to be Minecrafted simply for not being sycophants. That said, remember, guys, now Vic can appeal. The fight that matters is here. He can be saved.
I got something I'd like to say about this, Nick.
Sure.
I've been real busy the last month, and not on Vic's case necessarily. I've got 14 to 16-hour days are my life right now because a number of large things have happened, which is good. I'm not complaining at all. But so I haven't really been able to keep up with all the hue and cry. I just assumed it was out there. I'd ask the question to anybody. If you were hiring a lawyer, would you hire the one that screams that the battle is over at the very first sign at the very first thing that happens? If we have one good outcome, we won the whole war, or if we lose, the war's over. I would want the lawyer who goes, "Nah, we ain't done yet." That's just me.
And I would want the lawyer who knows well enough that these are steps on a path, and that the path doesn't just end after something either goes your way or doesn't. So,
if it makes anybody feel better, of course I would have preferred a better outcome than this.
Right.
But it was always within the realm of possibility, and always in our analytics that it could go this way. I mean, you when you go to trial, there's a 20-something% chance, in my opinion, that you're going to lose no matter how good your case is. A 20% chance you're going to win even when you shouldn't. You know. So.
Hey, the real Lady Rackets is in the chat.
Hey, Lady Rackets.
She says, Ty, we are proud of the work you've been doing. It's just the beginning. Love you.
Thank you. Right back at you.
Oh, hey, Jeremy Hambley's in the chat, too. He says,
hey, Jeremy.
F for respects of Nick's Twitter. R.I.P. Sweet Summer Child. Hey, thanks, buddy. Hey, Jeremy, can you do me a favor? I'm going to have my intern at Law Archive send you a message either tonight or tomorrow. She's probably asleep tonight, but that way we can keep in touch on Twitter through that.
And Jeremy, hey, from a fellow RPGer, I've heard a lot about you. Never met you, but we know some of the same people, and they speak highly of you. So.
Wow. Well, nice praise.
I'm not seeing the stream, so I can't.
Well, yeah. Don't worry about it. Don't worry about it.
Yeah. I'm sure you'll loop me in if necessary. Sure.
But yeah, Hambly, I have something to talk to you about. I think it might pique your interest. Aku says, "Hey Boomer, first time I can make it live. Just wanted to say thanks for your 9/11 stream where you talked about RockCon. I got to go and meet Vic. Hey, you're welcome, man. I'm glad you did." The West Nile Chan says, "Hey Nick, long time no see. Question for you and Ty. If an appeal is filed, can Ty attempt to get the second amended pleading admitted, and should he?" Absolutely and absolutely.
You'll have to wait for our appeal brief to see the details on if there is one. Of course, I'm talking hypothetically. But yeah, the appeal there. Yeah.
If there's an appeal, then yes, the argument would be that the second amended pleading should be admitted under Rule 63. The rule is clear and unambiguous, and that the failure to recognize the pleading nor strike the pleading is reversible error, and that should be argued. Absolutely.
That sounds like a pretty cogent argument, Nick. I might make a note of that.
Well, I was at the hearing, and that's the argument that was basically made in the courtroom.
Yeah. Well. Look, I'm in an awkward position because obviously I don't want to criticize the court. The court has a job to do, but I do feel somewhat strongly. No one should think for a moment that I just went, "Oh darn, that happened."
Right. Well, and in fairness to the court and Judge Chupp, he did lay out his reasoning for why he chose post facto to ignore that amended pleading. And so then the appeals court would have the opportunity to weigh in on whether or not his reasoning is the proper reasoning.
Right.
So,
right.
Because it's not a clear-cut issue.
Yeah, all kidding aside, going after the judge because of this, I mean, I know people are angry and all that, but, look, in the real world, judges are way too busy to have grudges against particular parties. There's no, it just didn't go our way. And we did make some mistakes. I made some mistakes. I mean, there's no question about that, in my mind at least. But, I've never seen a perfect football game either. Never. It happens. So to the extent that anybody cares what I think, slagging the court, if it makes you feel better, I guess so. I mean, look, it's a free country and we elect our judges. So our judges are, in my mind, always subject to the same rules that any other politicians are. But I don't believe that we're the victim of bias in any way on the part of the court. I really don't. And I'm not saying that to suck up to like I suck up to people. I'm not sucking up to anybody. If I thought there was bias, believe me, you'd know it. There wasn't bias here. The judge just didn't see it the way I would have liked him to see it. And so we're going to go to a tiebreaker, basically, hypothetically.
Right. Dustin Fritz Farr says, "I've been wondering if the law is so broad that lawyers can specialize in certain fields, Shouldn't there be judges that do the same so as to increase efficiency in the legal system, or would it just add more bureaucracy? There are areas of the law where this happens.
There are special,
yeah, particularly
but
the Patent Appeals Court.
yeah. Well, and it happens. It happens unofficially, even in local courts, like in Tyler, for example. The judge that I ran her reelection campaign the last time she ran, and we crushed our enemies. She was essentially the unofficial family law judge. I mean, if you filed a family law case, 80 or 90% of the time, it's going to go to her, because she actually liked that family law was kind of her passion, and all the other judges were like, okay, fine, take it. But in general, the best idea that we seem to have is that cases are assigned randomly, because again, that helps. If you don't know which judge you're going to get, you got to bribe them all, right? If you're going to mess with the system. So
that's a joke.
Yeah, it's a very definitely
just so we're clear on that.
But it's an intelligently designed system that we have. It's not perfect, but I don't care what happens in this case. No one will ever hear me say that the system is broken. It's not. It may not work the times I need it to work, but no, we have the best. Believe it or not, if you think it, those of you who are religious, if you don't believe we live in a fallen world, put this to you. The legal system is the very best that mankind has ever come up with in 5,000 plus years of civilizations. This is it. So, yeah. But it is the best system, in my opinion. I think you'd agree with me on that.
Yeah, I would. It's just unfortunate that it is expensive and time consuming, but we're people. So let's go on. 2012 Jameson says defendant's TCPA was based on safety of community, but all the claims were past statute of limitations. How's it not prejudicial against Vic for him to have to prove they didn't happen? Also, why did court consider it a fact that Vic was a predator? I don't know that the court found that fact, and that's maybe, I don't know if you want to comment on this, but that was a section that was interestingly absent from the ruling, and we'll cover that in more detail when we read it.
I don't.
Okay.
I don't.
I'll talk about that when we actually read through the document in a little bit. Indie Visualist says, in February, Kick Vic said that Vic would be in jail and his life destroyed. Now he may start his own studio. His fans are with him, and Kick Vic are the ones defending their actions. Don't let Kick Vic move the goalpost. And again, that's something else people need to
that's
consider.
A good point. That is a great point. It really is.
Is that by
if anyone thought they were going to destroy Vic in February, so yeah, it didn't work, fellas, ladies, whatever.
Right,
it didn't work. And it's not going to work.
And that again is largely due to you all out there in the chat who do support Vic and have stuck with him through all of this.
That's right.
So
you guys, the thing about this case now is everybody can look at the evidence. The depositions are out there, the filings are out there. Normal people can weigh the evidence and decide for themselves whether or not the accusations are credible and whether or not the punishment demanded is in any way reasonable. That couldn't have happened without the legal case.
Right.
The legal case might not at the end of the day solve all of our problems, but it did enable us to get the evidence out there. So, I'm not unhappy with that result.
Right. And I've stated for a long time that I think that's as important as the legal case is how Vic is perceived in public and most importantly in the community where he does business and where his fans are.
Well, as you know, Nick, we've talked privately about this. I think it's more important than the legal case. I've always analogized the legal case to an anvil, right? There's gonna, it's the ultimate thing, but the hammer is the PR, the public battle. No, I think, I'm very comfortable with rational people evaluating the evidence that's out there and deciding whether or not my client's a predator. I'm very comfortable with that analysis.
Yep. Let's see. Blink Your Eyes 1400. This one's a little bit different topic. Says, did you guys hear about the tragic loss of the B-17G Flying Fortress 909
Yes.
and the 7 people who died when she crashed at the airport in Connecticut this past Wednesday? F in the chat for the Flying Fortress.
Tragic to lose the people. Obviously, you never want to see there just aren't that many of those left. Are there any flying left now?
I have no idea.
It's amazing given that we made thousands and thousands and thousands of those things. How few of them there are. But
right.
Yeah, that was terrible.
Jorel Navarro says, some people need to knock off the Chicken Little nonsense just because Chup didn't rule the way they wanted. Stop being snowflakes. 2, can Chup be reprimanded for his ineptitude in the case?
I'd agree with that.
Yeah, and can Chup be reprimanded for his ineptitude in this case? Not based under any facts that currently exist.
A mistake is not punishable, nor should it be.
There would have to be,
and again, the statement assumes there is a mistake.
Right, there would have to be some
for there to be, and there's no evidence of that.
Right, there would have to be something that is completely out of the realm of anything we've seen. That there's not really any.
Yeah. I mean, there are cases out there where they've tried to get. Yeah, I'm sorry. There've been cases out there where they tried to get people recused because they just blew it badly, and the court said, no, that's not a valid ground. So
right.
Nah.
And then finally, I still have faith in Ty. So there you go. Mike Walters.
Thank you.
To you, Ty. Does Vixx still have to pay penalties while the appeal is going on? No. Do you want to? No. I've covered this.
No,
I could explain it.
That. Yeah, you've done it perfectly as far as I'm concerned. Go ahead.
Yeah, the long and short of it is, during the appeal process, the only part that has to be put up to stay the effect of a judgment is a bond for what's called compensatory damages. Those compensatory damages do not include sanctions, and they do not include attorney's fees.
There is a point. I heard you describe this last night. I started to text you about this. We don't pay filing fees for motions. We ought to. That might not be a bad idea. So no, the court costs are essentially insignificant, and the defense doesn't pay anything when they answer.
Oh wow!
So,
in Minnesota, it's unless you are ruled IFP, it's $100 for a motion and $75 for a response.
I'm not sure that's such a terrible system.
It is when your clients are poor, but not too poor, right? If they're not poor enough, it's really, really rough on a family with like a $30,000 income. It's really, really tough on them.
Yeah, because $100 is a lot of that's their disposable income possibly for a month or some huge period of time.
Right, and especially if they're paying a $75 motion response fee, that's just brutal.
I just don't. No, I don't agree with that. Making people pay to respond to a lawsuit,
well, that's how it goes.
But see, the Texas filing fees are more for the plaintiff, though. I think that's what Texas does. We probably collect about the same amount of money on the filing, but we put it all on the shoulders of the plaintiff.
Sure.
I like that better,
Right. And then he says, if you can say, we've already covered this, but why do you believe Judge Chup ruled the way he did on the remaining counts? Because it makes logical sense based on the rulings that he gave in the courtroom.
That's the salient point here. If the court believes it did it right, then it should have done exactly what it did today. I mean, and if the court changes its mind, then it has to change its mind on rulings it's already made. That is not likely. It happens, but not often. So.
And really quick, when I said if they're judged IFP, that means it's in forma pauperis. It means that you're ruled to be poor enough to not have to pay the legal fees for filing, because everybody is guaranteed access to the system as a legal right. And so if you're below the poverty line, or if you are on some sort of government aid, typically speaking, your court fees are going to be waived, because that shouldn't be the bar to you being able to access the legal system. And then the final question from Mike is Vic working with Sentai, Viz, or Bang Zoom? I don't know the answer to any of those, and I don't know
the answer either, actually.
Yeah. I can tell you guys this, that already today, I received a message from someone with the ability, someone with the ability to make something happen, let's put it that way, on how to help Vic going into 2020, and to work on formulating a plan, and for input on that. So, Vic is still getting work. Vic will still continue to get work going into the future. This ruling really is a continuation of the hearing date, more than it is some new fresh wound. I mean, it always sucks to have the ruling come down, but really nothing has changed between today and September 6th, other than we now have finality. So.
Right. Yeah. I mean, obviously, you would rather have gotten a different ruling, but at the end of the day, when the most likely event happens, given the way the hearing went, it's kind of hard to have to be defibrillated about it. I mean,
right. Diablo says, okay, guys, before everyone gets uppity because Vic lost, uppity, how dare you, sir? Q eye roll. There is a thing called appeals, and Ty has a good chance to successfully appeal. As the Beard tweeted earlier, it's only halftime. Gentlemen, we got this. So there you go. That's kind of a statement, more than a question. Ringwraither says,
that's what I feel.
Yeah. And Ringwraither says, if we were to go to the appeals court, and if it does go in our favor, will anything happen to Chup? No. Very unlikely.
No.
Are there repercussions for bad rulings? I mean, the only repercussions for bad rulings are at the ballot box for state judges.
Yeah, well, yes, but also, look, if you are a professional and you take your job seriously, being told you did it wrong, you're not going to like that. I mean, that's I've never heard of a judge that just said, I don't care if they overturn me or not. Oh, I've heard some of them say it, but I didn't believe it.
Right.
I think that, look, I mean, ask me how much I've enjoyed the last month in this case.
Right.
Okay. I mean, no matter what my opinion is about the mistakes that I think were made, or et cetera, I did not like the outcome of the hearing. Not wild about what happened today. I'm just not shocked by it. So, but no. If we punish judges for making bad rulings, we'd have no judges.
Exactly.
Because judges are fallible, just like all the rest of us.
And the law is broad, and they rely on other imperfect people to help guide them through it. And that's just how it goes.
Listen, I have been in appeals cases where I've read them and said, oh, my God, what were they smoking?
Right.
It happens. I've been in appeals cases where the ruling was crazy, and we file a motion to reconsider, and they completely rewrite their opinion to produce the same result. Okay.
Yeah.
So, it doesn't work every time, but it works right most of the time. So that's what you do. You play the odds.
Right. Omega Zero.
Real lawyers know that, by the way.
Yeah.
But anyway.
Omega Zero says, had to block the funny sleuts today after seeing them on Twitter, to use a football phrase, spiking the ball before crossing the goal line. Can't wait until this comes back to bite them. # funny sleuts. So
I have a question, Nick, for you. I mean, it's a real question. I mean, as you know, I'm not a Twitter expert because, about 8 months ago, Brittany showed me how to tweet something. I think I still text you when I send a tweet out. But leave me alone, man. Respect your elders, young man.
I'm just chuckling. I've said nothing.
Okay.
I'm just chuckling.
I felt judged. Do people actually care what those people say? It's an honest question. I'm serious. I mean, Does anybody really care?
Twitter isn't a place for Twitter is not the place for legitimate caring to occur on anything. Twitter is
I mean, look, I've gotten words of encouragement. I checked Twitter maybe. I think I checked it twice in the last 2 weeks, and I think I tweeted something both times. And I certainly appreciate the words of encouragement that I read and stuff. But some random crank that hates me that I've never heard of be a bot. I mean, I don't care.
Right.
So I know that I'm a relic from a different age and all that, and I know that social media is important to everybody, but I would make an appeal to everybody out there. Don't let negative, vile people just step into your life just because you have a Twitter account. There's this cool button called mute. I love it because if you mute someone, you never see their stuff and they don't know that. So you get the satisfaction of knowing they're out there screeching at the clouds and you don't see it. Anyway, sorry, I didn't mean to go off on a lecture, but this is all still somewhat perplexing to me. I care what my friends think of me. I care what my family thinks of me, my clients. If my clients and my family and my friends like me, I could not care less what some random person that I've never met thinks.
Right.
And because my life doesn't change one bit because some idiot on Twitter screeched something about me. And that's true for everybody out there. Don't let these people get under your skin. It's not worth it. They're serious. Who sits around slagging people for no reason on Twitter? What kind of a pathetic life would you have to have? Don't let those people in your life, man. Don't. Sorry, I didn't mean to go off on that. It is just a strange thing, right? It's like, who cares?
Yeah.
Yeah.
Well, Twitter sure cares when you sit around slagging people. Trust me.
Well, yeah, it's a little circular though, right? Who cares what Twitter thinks? Well, Twitter cares.
Well, I'm just making a joke about them suspending my account.
Oh yeah. Well, that's obnoxious because you actually use Twitter to let people know when you're going to do your stream and stuff. I mean, they're legitimate. Look, I want to be crystal clear. This is not some grandfather saying, "Quit that interwebs." I think the internet is the greatest advance in information technology since at least Gutenberg's press, and probably even more than that. The fact that I can look something up today in 5 seconds that would have taken me hours, if not days, to look up 30 years ago is just remarkable. So no, I mean, the internet's a wonderful thing, but the downside of it is it has enabled the 24/7 communication, has enabled some of the vilest people, some of those useless people on the face of the earth to band together and step into your lives. Don't let them. I don't. I couldn't care less.
Right.
Anyway, I'm sorry on a lecture, but I all this Twitter stuff. I'm going. Who cares?
Well, anyway. for some people, obviously, like your client, it can matter, but I get what you're saying. For most people, you're saying don't let it get under your own skin.
Well, and I want to be real clear. I appreciate words of encouragement that I've seen on Twitter. I truly do. Thank you very much. And there have been times, well, that's nice to say, I mean, it makes me, what I mean is don't let negative buffoons that you don't know just sweep into your life and start getting you upset because they're saying horrible things about you. They're idiots. Who cares? You don't even know these people are real, right?
Right.
I mean, the tweets you've referred to, just.
I'm gonna propose something to you. Can we cut your video feed and see if it increases the audio?
Sure.
And then I'll
deny everyone my classic.
You're moving like 4 frames a second anyway. It's really Yeah.
Well, okay, yeah. So it really are chiseled. No, that's fine. I couldn't care.
Yeah. So
So what will happen? Do I like
you
push
just
a
press
button on my end?
press the button that turns off your video and leaves you with that. Perfect. We'll see if that works, and if that doesn't work, maybe I can have you just call me, because it's really choppy. So
Okay. Okay.
okay, but
Yeah.
okay, Pyretta
Yeah.
Riddle.
Yeah.
Oh, let's. Are we good
Yeah. Go ahead.
to move?
Yeah.
Okay,
Yeah. Yeah.
Pyretta Riddle
Yeah.
says,
Sorry.
"The con slut uprising is here. Time to act, my fellow con sluts. Well, I'm not feeling well, so gonna have an early night. So I love you, fam. Hey, later, Pyretta.
Hey,
Nylox7.
Nick,
Yeah.
no. I gotta hear it. I gotta hear it from you.
The con slut. Con slut.
Yeah. Thank you.
You're welcome.
Just had to hear it.
Nylox7 says, this is to both of you. How do you think advanced AIs, human level, would change our legal system if they began acting as counsel or assisting counsel and judges? The interesting thing is they've tried the AI judges in regards to criminal appeals, or not criminal appeals, bail hearings. And at those bail hearings,
I heard about that.
yeah,
Go ahead. Yeah.
the way it worked out was the AI was far better at determining who was a risk and who wasn't a risk at the bail hearing than a group of judges over a several year period and a sample size of over 500,000 cases. So as far as things like bail hearings go, maybe it's a good idea, maybe not. But the rest of it, I have a hard time with it.
Hard to see how. Well, said a different way. Bail hearings are you're trying to solve for one problem, right? Is that person going to jump bail? And you've got a fairly discrete number of variables that you can quantify. I never say never when it comes to technology, but it's going to be a long time, I think, before all of the ins and outs of the human brain can be accurately replicated. And of course, if you accurately replicate the human brain, now you've got a nerd asshole in the computer. I mean, didn't they have a problem with it? Didn't they have some AI that became racist and
oh yeah, that was
said all
Tay.
kinds of horrible things?
Hashtag justice for Tay.
Yeah. So so I think we're a good long ways away, and it's not going to be a panacea. Because the hard part in the law isn't applying the law, believe it or not. It's deciding who's telling the truth.
Right.
I mean.
Okay, so let's move on. Pooh Zerker says, 2 years ago, I received a scholarship for law school and dropped out before the first midterms. I've been using meth and liquor to drown out feelings, but I've been thinking about things differently since I found you. Dude, first of all, don't ever use meth or liquor to drown out feelings. Liquor should be used in a celebratory way, not in a way to resolve things. And there's a lot of reasons for it. You should use liquor on a high, not use liquor to get to a high. It doesn't work that way. Meth you just shouldn't use. But I'm glad you're thinking about things differently. You shouldn't be ashamed for leaving law school.
Exactly. I was about to say that very thing. Law school is horrible. Yeah. No. If you were smart enough to get into law school, you can get out of law. You can get through law school. Not everybody is cut out to be a lawyer.
Yep. You cut out.
It's actually probably because they're better people.
Yes.
Yeah.
Lawyers are.
You heard me. I said, if you're not, sorry.
No, I was going to say lawyers are terrible people.
Yeah.
Absolutely.
As a general rule, now I know a lot of very fine people who are lawyers, of course, but as a profession, I think we're hated for reasons that, as a profession, we've pretty well earned.
Yep. Batman says, "Tell Ty to show feet." Well, they would be in 144p and at 4 frames a second, so we're not going to do that.
No, I'm not showing my feet. No. Sorry.
Slipknot Draken says, "Hey Rackets, may I shill for a second? I'm a trucker hoping to raise a down payment to bridge a gap on a low API loan so I can buy my first truck and pay costs for an LLC. The GoFundMe is Driver's Down Payment and Startup Fund. Thanks." Well, yes, you can shill that, and so people can check out Driver's Down Payment and Startup Fund if they want to check that out. Yeah, what's up?
And hey, good for you, buddy. Good. I'm just saying, good for you. You're
Hmm.
actually learning to do something that people need. Drive stuff from one place to another. Good on you.
Yeah. Definitely not Ron Snack Tray Toye says, Chup to himself says, quote, well, this is a sheet show and I kind of dropped the ball. I could get these jackals to make up. I could fix myself and get appealed, or I can roll with it and get appealed. F it, we'll do it live. So there you go. BTL Video Production says, why do both of you think Chup ruled the way he did? We covered this earlier,
Yeah.
so maybe I can summarize real quick. It's the logical outcome based on how he ruled at the hearing. To rule differently, while it was a possibility, but as I said yesterday, this is kind of the most likely outcome of any of the possibilities. He could have ruled differently, but if he thought he handled the hearing correctly, then this is how he would rule on the remaining counts. So that's how it goes.
Yeah. And let me add one little thing. I'm going to say solely for the purposes of discussion, okay? If you were a judge that thought you had messed up and you just wanted this off your plate, and I'm not saying that's the case here at all. What I'm saying is I'm simply, going along with some of the premises of the questions. It's probably the smart play to do it this way, right?
Right.
Because most cases don't appeal. Most appeals settle, and there's no guarantee that an appeal is going to be successful. So if you want to get rid of something, this is the way to do it. Now, I don't think for a moment that's what happened in this case. I think the judge, I take him at his word, and I think he takes his oath seriously. He didn't see it the way we see it. Just that simple. No, there's no there. We don't have to assume idiocy. We don't have to assume nefarious or anything like that. He just didn't see it our way. That's it.
Yep. So then he says, evidence shows Funimation, Markey, and the Nasally Dwarf are up to shady stuff. People started showing reviews that show Chup isn't the best judge in the system. And let me quickly dispel this. Judge reviews are largely going to skew to people who are mad about them ruling, and typically judges rule against one person in every ruling. So there's a
half the people in the courtroom are going to be pissed off.
Right.
I think you said. I think I got that. I think I heard that from you, Nick. Something like that.
I think I said if you're doing the best, at least half of the people hate every lawyer. Half the people in any room hate
right.
you.
Oh, yeah, okay, that's right.
And that's only if your client
Totally
doesn't. Okay, so next we've got Polio64 says, hey, Nick, really bad day today. AOC ate my baby and Kiwi Farm stole my dog. Man, that is rough. That is rough.
That's hard.
Rick1186 says, kick Vic showing they're still premature ejaculators, but this is why appeals exist. Ty, I have faith in Ty and his team will do the job he is hired to do and do justice for Vic. So there you go. West Nile Chan says, Nick, AOC broke into my house and ate my baby. When I tried to stop her, she clapped back and said it was for the greater good. Then she jumped out of the window screaming Captain Planet. That's horrifying. Gethrelkin says,
a lot to absorb in that.
Yes, much processing needs to take place. Gethrelkin says, hey, Nick, has Ty read Sarah Hamidi's article? If not, I'll send it to you.
No, she is.
She is interested in staying updated on the case for future coverage. Is she allowed to get exclusive coverage? Also, your Twitter is down. Do you still have an intern? I do. And everybody who needs to get updates about the show can follow my intern at Law Archive on Twitter, and she will tweet out show news. That'll be most of what she's tweeting out will be show updates. I don't want to waste her time on Twitter. So there you go. Brian Dewig says, Nick, we are people. I think the opposition disagrees with that assertion. Well, that's fine. Believe me, I think they are many people each. Will S says, good evening, Nick and Mr. Beard. I've been watching since Nick first covered the case. Thank you for everything you guys have done for Vic. Also, Mr. Beard, do you have a favorite Dungeons and Dragons class?
Believe it or not, of all things, druids. AD&D. I was always an AD&D person, so I don't know if the druids made it into the basic D&D or not. But yeah, I always like to play druids because you can use a sword, and some of the druid spells were really cool.
Yeah, they were pretty funny. They really got terrifying when they got the polymorph self.
Oh yeah,
and could turn themselves into like elementals.
One of my favorite spells is pyrotechnics. It doesn't cause any damage, but it's the equivalent of about a ton of fireworks going off all around you.
Right.
And you drop that in the middle of a group of magic users or something, and anyway. But yeah, druids definitely.
There you go. Pooh Zerker says, Ty, you'll never know how much hope and motivation you have given us internet randos. This suicidal random thanks you, sir. Don't be suicidal. Let me just say that.
Don't be suicidal, man. It's never as bad as it seems, I promise you.
Cesario JPN says, if I recall correctly, on mobile and busy, 40-ish B-17 frames still exist, less than a quarter, 10 ? Are airworthy and flying. 5 of the survivors have genuine combat provenance. The rest don't. There are at least several complete wrecks. So there you go.
Yeah, but the thing is, they are going to wear out, and we see that with some of our museum warships. The battleship Texas, for example, is corroding badly. I wish there was some way where we could just, magically seal those things up so that they could last forever.
Yeah, infinite money.
Yeah.
Brian Dewig says, does this mean Markey is back in the suit? Well, that'll depend on the appeal, if an appeal is filed.
Well, if there's an appeal, I'm sure she will be referenced in it.
Yeah.
So,
hold on. Okay, the Pie Baker says, Mr. Beard, if your client follows through with his studio aspirations and adds original works to that, I would love to talk, providing him licenses to screenplays I wrote, some of which I wrote as therapy for when I was falsely Me Too'd. So there you go. Pooh Zerker says, Ty Beard, quote, I don't care what people say, but I care for your opinion.
thank you, I guess.
Oh, wait, no, I think he's saying that to you. I don't care what people say, but I care for your opinion.
Yeah, so that's how I took it. Thank you.
Travis the Bard says, have both of you seen the Joker movie? I have not.
My daughter and her young man saw it yesterday and said it was really good. Has Joaquin Phoenix ever done anything bad?
I can't think of anything offhand.
No.
He's pretty good. James Duvall says, if you can clarify for me, I'm a little confused. So if the appeal goes in Ty's favor, does the game plan change, or is it still the same?
Same.
It's the same. It's the same game plan if the appeal goes in.
Look, and let me tell you, you guys, what the game plan is and has always been. It's to shine a light on all this stuff. We were never able to guarantee an outcome on the legal side of the thing.
Because you can't. You can never guarantee an outcome.
Of course not. Of course not. But what the legal process could do for us and did do for us is it forced evidence to be produced that you guys can all evaluate. Because here's the thing. We're wrangling over a technical statute. We're not wrangling over whether or not Vic did it. I think it's pretty clear from the evidence that he didn't do it. And it's absurd to try to recommend his career for that. We're fighting over technicalities. Now, I have no intention of losing this case. But if something happened tomorrow and we were wiped out and just couldn't go any further, we've accomplished the primary objective, which is to stop people from destroying this man. So, you say, oh, Ty, are you upset? No, not really. I'm disappointed, of course. And like I said, there are any number of things that I did not do as well as I should have done. As you said, Nick, I remember watching your stream right after the hearing, and somebody was, I think, slagging you or something, and you kind of chuckled and said, guys, you're not going to say anything worse than what Ty is saying to himself. And you were right about that. But no, I mean, we've put the evidence out there. Okay? I don't care, no matter what else happens in this case. The people out there can evaluate accusers and the accused. And I am thoroughly comfortable with what a rational person would bring from that. So, but the game plan, that was the game plan. And that's That's what it will continue to be. The ultimate outcome of the trial is almost irrelevant, okay? It's the evidence that matters. That's what we're after, you know.
Right, and remember that these people have...
no question.
These people have had 8 months to produce a single shred of evidence that Vic has done anything that they've said, and they haven't done it.
No,
so
yeah, we're those dozens and dozens and hundreds and all that stuff. That's, you know, that doesn't exist. I mean, you know, so and look, this comes off as self-serving, so that's why I don't like to harp on it, right? Because, you know, you say, well, I don't care if we win or lose. Oh, believe me, I care a whole lot about whether or not we win or lose. Okay, I'm not saying that. Never would I say that. What I'm saying is, we've already won a victory. We've already won a victory. And all the people out there in the tweet world that don't like that, tough stuffings. We have won. The only question is, how big of a victory are we going to win? Now, me, I want the whole thing. But if I have to settle for exposing the lies, hypocrisy, and just absolute insanity of certain folks, if I got to settle for that, and by the way, a guy that I've come to not only like as a friend, but genuinely respect as a truly talented man, if my worst case scenario is that we kept him from being destroyed and we exposed through depositions and through evidence the nature of the other side, look, I'm fine with that. Now, like I said, I absolutely want all the marbles, but I'll settle for the half the marbles that we got right now if I have to. So you know, the people out there that hate us are you know, you guys are, you're pissing up the wrong tree because we've already won. We've already won. You know, and you can deny it all you want to, but here's the thing: Vic is out there, and people are standing in line for hours and hours to see that man. Doesn't sound to me like y'all accomplished anything. Just saying.
Pooh Zerker says, Mr. Beard, I am an internet random. I'm a worthless soul who's desperate for some guidance. I would love to email you with my self-imposed problems. Oh, he cut out.
Friend, but I am real. I'm happy to give people the benefit of my opinion, but I'm not a therapist. If you've got some issues, get somebody that really kind of knows what they're doing. I'm just a guy that, you know, has an opinion, but you may, you know, send it through our website. If I can, I will, but please don't be offended if I don't reply, because I am extraordinarily busy right now.
Yeah. Okay. Next is Cloudfire181 says, Ty doesn't need to respond, but I felt mediation so late in the game was a waste of time from the judge since he already ruled to dismiss 12 out of 17. Also, Nick, my dad stated he was up for the chat about the Clintons. That'll be very interesting.
What now? What is this? What is this?
It's a chat from a man who worked closely with the Clintons.
Oh my goodness. So. My phone's gone off. Hold on. It's talking. Stop talking, phone. Okay. Sorry. Yeah. I'll watch that stream. That ought to be very fascinating.
Sure. We've got just a couple left, and then I can let you get back to your evening.
Yeah.
Lady Titania Lady Titania Games says, I just want to say thank you, Ty, for all you do. Despite what happens now, I've met people who are willing to lift each other up while the other side makes lists like Nazi propagandists. We were both on 2 today. So you're both on 2 lists.
Well, you know, let me just tell you, the day ain't over yet. not by a damn sight. So don't, you know, we're not finished. And thank you so much. Appreciate the support.
Yeah. A Burley Knowles says, hypothetically, if a lawyer is in a hearing that's going bad, will the lawyer prioritize getting things in the record to help with appeal?
Oh, theoretically, yes. But here's what you run into. It's a process. if you think that the judge is starting to see it your way, my general inclination is to keep trying to pull him in my direction. The record, getting stuff in the record is whatever, it includes everything you filed. So, you do have to get, reversible error pinned down if you can, but no, it's a minute by minute thing. You're constantly trying to judge the court, how they're, and of course, if you're overconfident, like most good lawyers are to some degree, you always think you can swing the judge back to your side by the strength of your persuasion. So anyway.
And then finally, Mike Walter says, at Ty Beard, why is law Twitter so wrong? I got into it with some of them on your halftime tweet, but since I'm not a lawyer, I got a headache dealing with them. How as a layman do we argue with them without wanting to bash our heads?
Don't.
Best
look,
advice.
Look, here's the thing, right? Any expert, and I'm putting those words in air quotes, if you could see me, I'd do it. The question I'd ask to any expert out on Twitter is, if you're so brilliant, how do you have time to be on Twitter? I certainly don't. Hell, I'm working 16 hours a day these days. I don't have time for that. So you're talking to people who literally have nothing better to do with their time than sit there and yell at the clouds that they're smarter than everybody else. Don't waste it. Your life is more important than that. Go do something fun. But same thing. Thank you for rising to our defense. I do appreciate that, but they just aren't worth the trouble, in my opinion.
Arctic Pride says, for Ty, be sure to hit up Railroad Seafood Station, Saltwater Grill, or Blue Cove before leaving town. Great food. I've eaten at Blue Cove. It is very good.
I am but a mere humble servant of my client, but we always eat good here, so I think I'll be fine. But thank you.
All right, the next one, this is probably the last one, then I'll let you go.
Okay.
And then I know there are some more questions for Ty, but really we're running out of time, and I believe I can field most of them. Luz Maria Arroyo. What?
Oh, I was saying, as you know, I was going to say to everybody, I wasn't avoiding the stream for any particular reason. I didn't really want to talk about the case before mediation because I was, wanting the court wanted us to go in good faith, and that was it. But I'll probably be back. I mean, I'm not hiding or anything.
Right.
I've just, like I said, had a lot going on lately.
Yep. And I frankly, I didn't invite him before mediation because there's mediation.
Yeah.
That's how it goes. Luz Maria Arroyo says, Ty and Nick, thank you for arming your army with knowledge. Scientia sit potentia.
Well, I believe Mr. Rekieta is the one that's doing most of the arming here, but I appreciate you putting me in his category.
And then Poozerger says, take care, sir, Mr. Beard. So, Mr. Beard, with that, I will bid you adieu. Unless you have any final things to say.
Yeah, I guess. Like I said, it's never as bad as it seems. It's never as good as it seems. This is just another step in a very long process. But I do want everyone out there who supports us, Vic, whatever, cogitate on that for a moment. We've already won. The only question in my mind is how big a win. Because at the end of the day, they didn't destroy him, and they're not going to. It's no longer in their power to do so. And at the end, that is the victory that we had to have. So I'm satisfied. I still want to win the whole thing. Don't get me wrong, but no, this is all this. Y'all are dead. Y'all are dead. Y'all are dead. No, we're not. Not even close. So anyway, it's great to be back on the stream, Nick, and I appreciate everybody. But I am going to have to go to bed because I got to get up in about 4 hours.
Yeah, we'll get out of here.
Y'all can all pray for me pray that I win the fishing tournament. I mean, send out good vibes on that because, not going to happen, but hey, it's worth it. All right, my friend, you have a great one. Bye-bye to the stream. Enjoyed talking with y'all.
Yeah, go raise some money for charity.
Absolutely. Talk to y'all later. Bye bye.
All right, man. Have a good night. Bye. Okay, 1 second here. There we go. Okay. So. Anyway. Let's see. We've got a couple chats have come in. Since that, Seth says, and then what I'm going to do is I'm going to pull up the ruling, and we'll go through it in just a minute. Seth says, seems like Kick Vic showed up in chat to talk a lot of stuff today. Doesn't them watching you just help you grift even more money? It's pretty bizarre. Clown's gonna clown, I guess. Well, I mean, kind of. Thank you for watching, I suppose. Bryce Byerly says, there's a reason the old saw goes, the wheels of justice turn slow, but grind fine. We are in this for the long game for both Vic and your firm, and we are looking forward to seeing you grind them until they give. So there you go. Fairy Tale Master says, hey, Nick, did you wear your ugly shorts in Hawaii? Yes. On a serious note, did the judge dismiss the charges just to allow Vic to appeal immediately? I don't think the judge had some sort of motivation for that. So that's just how it, that's just the judge ruling in the way he wanted to rule. So there you go. Let's see. Was there anything else that needed to be dealt with immediately? No, I think that's it for now. Let's get over to that ruling. 1 second here. Oh my goodness. We've got this one. That's not what I want at all. Hold on. Everything got screwy here. Aha! Do this first. Okay, hold on. I'm getting all the screen set up over here. Here we go. We've got this. Sorry, I'm rearranging my windows here. Okay, here we go. There, look at that. That is the current state. Well, let me just refresh it and make sure. Nope. There we go. We're at, this is the GoFundMe for Vic, which has gained quite a bit of money today, well over $1,000, with the vast majority of that coming after the ruling. So we've got lots of donations have come in. I think it's pretty clear what people want to happen with this. I think it's pretty clear that people want Vic to fight on, that this is about standing up for it, and people do support Vic. I mean, that's just where we're at, right? It's amazing, and thank you so much for continuing to contribute to the GoFundMe. It doesn't go to me at all. Not a penny. I've never had access to a penny of this GoFundMe. To all you morons who can't figure that out, this money goes to the benefit of Vic entirely. And just so we're clear, I've said this before, but if Vic fired Ty tomorrow, the money wouldn't go to Ty. There would be an accounting of everything, and whatever was left and whatever new came in would be directed to a new law firm. And whatever was left would be Ty's responsibility to send to the new law firm, or to return to the client to then send to the new law firm, or whatever he's going to do with it. So this isn't some weird thing that people are making it out to be. This is just money that has been raised for Vic to fight this lawsuit. And I appreciate very much the contributions to it, because it's such a slap in the face to these whiny people to these whiny people. Ooh. And I can already see them in the chat being literally stupid. Because if they think that GoFundMe allows me to take a single penny out of this, then they have, I guess, brain damage. There is no way for me to do it. There never has been. So that's fun. But there you go. Anyway, let's you know, if you choose to keep donating to the GoFundMe, I was asked by Derek Padua, the Tao of Dragon Ball guy. I think I pronounced his last name correctly. I was asked by him what my plans are for the GoFundMe. My plan's simple. I don't see any reason to close it. I don't benefit from it. I don't get any money from it. So it'll stay open as long as the suit is available for people to contribute. So, and if you want to know about like keeping a GoFundMe open for a really long time past what you're needing to purchase, just go ahead and ask T. Greg about that. He's very good at doing that with those CPAP machines and stuff. So, ooh. So anyway, there you go. There you go. We'll let's get this ruling pulled up here. Where is that guy? Aha! Here's this ruling. Okay, I think we've got that. Yes. Yes, we do. So here is the order. We're going to go through the order. This is going to be a more traditional law-splaining stream where we read through a document. You guys get to see every line of it, and we'll go through and I'll give you my thoughts. So here we go. This is order granting defendant Funimation Production LLC's motion to dismiss under the TCPA. Monica Rial and Ron Toye's motion to dismiss under the TCPA, and Jamie Markey's motion to dismiss under the TCPA. On September 6, 2019, this court considered defendant Funimation Production LLC's motion to dismiss under the TCPA, Monica Rial and Ron Toye's motion to dismiss pursuant to the Texas Citizen Participation Act, defendant Jamie Markey's motion to dismiss pursuant to the Texas Citizens Participation Act, the responses, the replies, the evidence, other documents on file, and the arguments of counsel. The court finds that the three motions should be and are granted in full. So this is, of course, the news that all of the claims raised by Vic Mignogna have been dismissed at the trial court level by Judge Chupp. I don't think that's a surprise to anyone in chat at this point. That this news came out around noon, 1 p.m. Central Time, I believe, and people have been talking about it all day. And of course, Ty and I have just been talking about it. But that is the actual wording of the summary. Now we're going to get into a little more of it. Plaintiff filed an original petition on April 18th, 2019. Defendants answered and then filed motions to dismiss under the TCPA. The parties agreed in a Rule 11 agreement filing with the court on August 6, 2019, that plaintiff's response to the TCPA motions would be filed on or before August 30th, 2019. It appears from the arguments of counsel and documents on file that plaintiff made a good faith attempt to file responses according to the terms of the Rule 11 agreement, but due technical errors was unable to meet the deadline. Therefore, the court finds that plaintiff's response to defendant's TCPA motion to dismiss is deemed timely filed. This is something that was focused on quite a bit by people, that 30 minutes was going to matter. It would be really, really a stretch for a court to quibble over 30 minutes, especially when there's a documented technical error. And courts don't really care for dealing with they like the e-filing system because it cuts down on actual paper, but saying that the courts are fond of e-filing and the wonderful smooth system that it produces is not entirely accurate, we'll say. So anyway, let's move on. On September 3rd, 2019, plaintiff withdrew the affidavits of Vic Mignogna, Chuck Huber, and Christopher Slatosh that were attached to plaintiff's response to defendant's TCPA motion to dismiss. Therefore, the court did not consider the withdrawn affidavits. This is a weird one because this is probably an appeal point right here. Judge Chupp ignores that unsworn declarations were filed with the attempt to rectify perceived issues with the affidavits. Issues that were not ruled on by the court, those were attempted to be added to the record, and they were attempted to be added in an amended petition. But that's not the only place they were attempted to be added. They were also attempted to be added in the whatchamacallit. At the hearing. Actually, I believe Ty made a move for a trial amendment to attach the unsworn declarations. Judge Chupp didn't rule on that trial amendment. He said, if I recall correctly, I'm gonna paraphrase, I believe, but it should be pretty accurate. I think I'm going to consider these. I've already read them. I don't know how I couldn't consider them, was what he said. So he didn't rule on the trial amendment, the motion for the trial amendment. And he said he was going to consider and already had considered them because he had read them. But then he's saying here that he doesn't. This is a weird inconsistency. And the next line is going to kind of flesh that out a little more. Plaintiff additionally filed plaintiff's second amended petition on September 3rd, 2019, which added additional evidence that was not included in plaintiff's response to defendant's TCPA motion to dismiss. That's not really true. That's not really true. What it added were the affidavits that were it added unsworn declarations to replace the affidavits, but that was a remedy to that problem. And Chupp even said you could have supplemented the response to the defendant's TCPA motion, and he said that. I'm not sure I believe Judge Chupp would have allowed an amendment to that motion response on September 3rd. I think that might be a little disingenuous, because if he's saying you could have done this, but then he doesn't allow them to remedy the error with the affidavits, that's playing both sides of the same coin. I don't think that is I don't think that's legally sound. It's also highly, highly prejudicial to the non-moving party, which kind of goes against the very spirit of these sort of dispositive motions. So I think Chupp is trying to have it both ways here, and if this gets appealed, I think this is going to be an issue that the appeals court looks at pretty heavily, because this isn't actually accurate. Ty can't say that, but I can, because I'm not in the case. Nothing in the TCPA, no, he's quoting here, and this is a very interesting quote. Nothing in the TCPA statute prohibits claimants from amending their pleadings. However, amendment after a TCPA motion is filed would be contrary to the purpose of the statute and possibly a violation of the Texas Rules of Civil Procedure. Let's check this footnote. See Laura Lee Prather and Robert T. Sherwin on the changing landscape of the Texas Citizens Participation Act, Texas Tech Law Review. So these are written, I believe, by law students. Page 152 to 153. Print version scheduled for publication winter 2019. Available online at ssrn.com. That's the Social Science Resources Network, or whatever, where you can find all sorts of academic papers. If SSRN is a pretty cool website, because you have access to stuff that normally costs a lot through paying for journals. But he didn't cite a Supreme Court case, an appeals court case, a contemporary district court decision. He didn't cite anything like that. And if you actually go read this paper, and specifically the quote, you notice at the end here, right down here, it says citation omitted. Let me tell you what the citation is. The citation is a case, and the citation is occurs. Let's see. Contrary to the purpose of the statute, the citation occurs here, right here. So on this line, Amendments after a TCPA motion is filed would be contrary to the purpose of the statute. The citation that they provide is to a case ruling on an entirely different statute. It's not going to a Supreme Court case that says anything about the TCPA. It doesn't involve a TCPA. It's actually the Texas Medical Liability Act, the TMLA. So the Texas Medical Liability Act is the statute that they're citing to here. This is a terrible citation for a TCPA to make a definitive statement like this. And I think it's actually like if Judge Chupp got this in a filing, he would be rightful to criticize the person filing it for misrepresenting what happened. This is really, really a bad citation. The Texas Medical Leave Act, or Medical Liability Act, if I'm correct, now I don't have infinite time, but I believe that this case citing here is referring to the Texas Medical Liability Act creates a new statute of limitations of 75 days from the time that notice is given of an intent to file suit under the TMLA. Okay? And what they're saying is that if you could infinitely amend your pleadings, you would defeat this 75-day statute of limitations. But that doesn't exist in the TCPA at all. That's a completely unique provision to the TMLA. So I could be wrong on that. I'm happy to be corrected, and I'll try and delve into that. But as a preliminary read, I think this is a very, very sloppy citation by Judge Chupp. And by omitting that citation and not talking about how this doesn't actually refer to the TCPA at all in the paper, that's some poor legal writing, in my humble opinion. And possibly a violation of the Texas Rules of Civil Procedure. This citation that follows here, now this is citing to the footnote here, but the internal citation that follows this phrase cites just to Rule 63, the very rule that you would use to argue that this is a proper thing to do, amending the pleadings. And lots of people amend their pleadings after a TCPA is filed. Now, this is the weird thing here. These people are arguing that amending a pleading after a TCPA is filed at all might be wrong. Now, Rule 63 simply says you can't amend your pleadings within 7 days of a trial. There is no case law to support this. There's none cited in the paper. I can't express how bad this citation is for this decision. So you'll have to, we'll have to see. Maybe the appeals court is going to agree. I think there are contrary Supreme Court cases out there that are more on point than an online only published academic paper on SSRN. But that's just me. So, Accordingly, the court did not consider evidence submitted after the agreed upon deadline in the Rule 11 agreement, with the exception of plaintiff's response to the defendant's TCPA motion to dismiss without the withdrawn affidavits, which was deemed timely filed by this order. So that's interesting, because in the motion paperwork, the affidavits that were withdrawn are cited. So it's, again, you've got this weird place where Judge Chupp is going to have to look at the motion document and then determine that various parts of the motion, which have not been stricken, don't apply because they're supported by affidavits that are withdrawn and are attempted to be remedied. That's going to be a likely argument on the appeal, is that they attempted to remedy the faulty affidavits with unsworn declarations, which under the rules is allowable. And the remedy for having a faulty affidavit, Like if you bring up that there's a faulty affidavit, the remedy is to allow the party to correct it. Because again, it's so exceedingly prejudicial to one of the parties to deny them the availability of evidence based on some sort of what you would call a clerical error. Now, Judge Chupp clearly did not consider any of the allegations of fraud or anything like that have been bandied about on Twitter. Judge Chupp doesn't mention that in the slightest. He didn't mention it in court. He basically said, I'm not really concerned with this. He doesn't mention it in his filing at all. And if he did, that would likely be reversible error, because they said, we withdrew these affidavits and attempted to remedy the faulty clerical error that occurred. And that's how it would go. Absent a showing of intent, a incorrectly notarized form is considered an error of form and would be remedied by correcting the form. So we'll go with that. But again, I'm sure everyone will disagree with me on that. I'm not so sure their legal reasoning will be very solid, but that's fine. The purpose of the TCPA is to encourage and safeguard the constitutional rights of persons to petition, speak freely, associate freely, and otherwise participate in government to the maximum extent permitted by law. And everybody leaves out this last part. Chupp leaves it in, but I think he ignores it. At the same time, protect the rights of persons to file meritorious lawsuits for demonstrable injury, citing to the TCRP, or to the TCPA. The TCPA shall be construed liberally to effectuate its purpose and intent fully. Everyone applies this line, which is from the statute, but they only apply it to the first part. But the second part is part of its intent. Protect the rights of a person to file meritorious lawsuits for demonstrable injury. So if you're going to say, well, we really want to allow these people to get out of a lawsuit quickly, you also have to say, look, we have to construe this liberally to allow merit to be shown. That's going to be, again, this is going to be brought up on appeal. This last line doesn't somehow obviate the second part of the phrase that it's referring to. Its actual stated purpose isn't obviated just because you want it to be. Its purpose is both of these things. It's conflicting purposes. So, like the Fourth Amendment, a warrant requirement and then reasonable search and seizure, a reasonableness standard. Those are conflicting purposes. And that's never mind. That's a long discussion. Plaintiff Mignogna has filed cause of action against all defendants for defamation, TI with existing contracts, TI with prospective business relations, and civil conspiracy. Plaintiff has also sued defendant Funimation for vicarious liability for the conduct of defendants Marky, Rial, and Toye. The court finds. Now, this is interesting. So that's a summary at this point. That's the introduction, a summary section. Typically, what you would see in a ruling would be a finding of fact and conclusion of law, because you would want to find specific facts that are relevant to the case, that inform the decision of the court, and then how those facts inform the decision of court would be conclusions of law, where they explain how those facts play into the existing law. You apply the law to the facts at hand, and that's how you come out with your conclusion. That section is absent from this ruling entirely. So now we just go on to some conclusory rulings by Chupp that aren't supported by statements. They are supported by assertion and conclusion, but they aren't supported by anything that either party could point to and say this is correct or incorrect. We just have to assume the record is whatever Chupp needed it to be to say these things. This is a weird part of the ruling. Because the appeals court is going to look at this and say, well, we don't know. I mean, we know he didn't include this thing, and whether that was proper or not, we have to figure out. But we don't know what he considered in any of this, because there's no section stating what was considered and what facts were applied to the law to come to the conclusion. So we've got the court finds The defendants have shown by a preponderance of the evidence that all causes of action against all defendants asserted by Plaintiff Mignogna are based on or relate to or in response to the defendant's right to free speech, right to petition, or the right to association under the TCPA. And he just cites to the TCPA. He doesn't say how they showed that. He doesn't say the conflicting evidence offered by the parties. He doesn't do any of that. So again, a court ruling on this, or an appeals court looking at this de novo, is going to say, we don't know what he based this decision on, so we're going to have to go back to the record and try and determine for ourselves whether or not that's true. I think they'll probably find it on many, if not all, of the cause of action. But maybe not. Maybe there's a legal theory I'm not aware of, and that would have to be brought up on appeal. Interestingly, he leaves this open for appeal when he could probably shut it down with a statement of the facts and the legal conclusions he drew from it, but he doesn't do it. Additionally, the court finds that defendants have shown by a preponderance of the evidence that the communications related to the plaintiff's cause of action relate to a public concern, and the communications involves allegation by the conduct by plaintiff that relate to health and safety, environmental, economic, or community well-being. So again, he doesn't say how that happens. These are the types of things where the appeals court may say that these issues get remanded back and they have to be properly decided with some direction. They may also just say, no, we think that this is true based on the record that exists. That's a possibility. Again, I think the most likely outcome at the end of the day is that the TCPA does apply. Unless I'm missing something, which is entirely possible. Unless there's some legal theory or case out there that says specifically that the TCPA might not apply to these particular facts for these causes of action. I don't know of anything like that. And so I think likely this is true, but the appeals court could still remand this back for an argument with an actual accounting of the facts. We'll have to see. We'll have to see. But again, he leaves these two things open for appeal, and I think if he could have just laid out his factual basis and legal conclusions for finding these things, if he just talked about what evidence was presented to support this, he could probably foreclose the appeal point on it. But he doesn't. And I think that's a little bit sloppy. So now we go defamation. Plaintiff has asserted in his petition that Vic is a voice actor who has performed in the voices of animated characters for over 22 years. This is the closest thing we get to a fact section, by the way. Mainly in anime productions. In June 2017, Funimation contracted with Vic to provide the voice for dubbed anime properties it was distributing within the US. 2018, Vic was cast as the English voice for Broly, lead character in the fantasy martial arts anime film Dragon Ball Super Broly. The cast also included Monica. Dragon Ball Super Broly was released in the US on January 16th, 2019, was an instant financial success for Funimation, earning $7 million on its first day and $24 million within the first 5 days of its premiere. In addition to his voice work, Vic attends fan conventions approximately 35 to 40 per year. He earns a sizable income from appearance fees guaranteed by contract with the convention producers and from signing autographs, taking photos with fans, and appearing on guest panels. So then he says, in addition to plaintiff's assertions, defendants provided specific evidence in their motions and replies that are before this court, and they have argued that plaintiff is a public figure as contemplated by Texas defamation law. He doesn't list any of the findings of fact, right? He doesn't list those factual assertions. This is the only finding of fact that he has, and it's from the plaintiff's thing. Now, this is valid. This is a valid thing to use, this finding of fact. These facts are evidence in the pleadings, so that's okay. But he doesn't list any of the supporting evidence, and he doesn't list the conclusions or any of the arguments that were made by either party. He just says that they did argue it, which is obvious. Of course they did. This court must recognize and apply the reasoning of the Second Court of Appeals in Lane versus Ferris, which has similar facts and circumstances as the instant case. It also has very different facts and circumstances as the instant case. So that's a weird one. He just says it. He doesn't go through and shore up what he could do. I think Judge Chupp could maybe even foreclose a limited purpose public figure argument under Lane versus Ferris. He could certainly make it a beefy argument. by laying out the facts that are similar in the case, this is how you do legal writing, by dispelling the counter arguments, dealing with them, and then applying the law as is from the Fort Worth Court of Appeals. He could do that, and he doesn't, leaving it open for appeal. And he does another thing here. Therefore, the court finds by a preponderance of the evidence that Plaintiff Mignogna is a public figure. We don't know if he means general purpose public figure. We don't know if he means limited purpose public figure. So this ambiguity is very, very weird. We don't actually know what legal standard he applied. We can maybe infer, because it's Lane versus Ferris, that it was a limited purpose public figure, but he doesn't say that. That's not in the ruling. And since he doesn't show the facts that he used to do it, he doesn't show how Vic inserted himself into the controversy, he doesn't show any of those things. He just says, well, it's like Lane versus Ferris, so he is. Again, weird sort of judgment from Chup, because he could put this stuff in there, make the argument, make the appeal more difficult, because then the appeals court could look at the reasoning, and the parties could look at the reasoning and either attack it or use it to bolster their appeals or their opposition to the appeal. Additionally, the court finds that plaintiff has failed to establish by clear and specific evidence a prima facie case for each element of his defamation cause of action against all defendants. And he doesn't say anything about the evidence that was raised. He just says, out of hand, that nope, all the causes of action. He doesn't say if any are met, if none are met, if one is met and others aren't. He doesn't say any of that. And again, he could limit the amount of appeals points that are out there, but he leaves it ambiguous. So very strange, because certainly many of the causes of action, a prima facie case definitely exists. Let me just give you an example. Ron Toye, through counsel, authenticated all of the tweets that he made. So he published statements to a third party, period. That's an element of defamation. There's a prima facie case for it, and all of that evidence is in the record. And that evidence was raised at the hearing. So there is no argument possible that that element of defamation against Ron Toye specifically doesn't exist. There's no possible way for the court to say that a prima facie case doesn't exist for that element of defamation against that defendant. Now, I would argue that all of the defendants, all of the elements are met by what's in the record. Even ignoring the second amended petition, all of the elements are there because all of that evidence is involved in both parties' filings, and it can be found in the pleadings, in the motion documents, and the affidavits. All of it. So because of that, I would argue that all of it is there. People can disagree and say it's not sufficient. That's fine. I'm saying I would argue that. But what is incontrovertible is that Judge Chup says that he doesn't fail, that he says a prima facie case for each element of his defamation cause of action against all defendants. That's a false statement. That is untrue. Definitely, some of the elements of the defamation claims must have a prima facie case. Even if you think one of the elements for each person isn't there, you can't say that none of the elements have a prima facie case, because pretty much everybody stipulated to publication. They included their tweets in their filings. The TDMA letters were included in their filings. All of these things exist in the filings, even against Jamie Markey. They're all there. So publication of a statement to a third party is an element. I think it's two elements. So there you go. Very, very weird of Chup to do this. I don't want to say it's lazy, but it looks really lazy. Tortious interference with existing contract. The court finds that plaintiff has failed to establish by clear and specific evidence a prima facie case for each element of his tortious interference with existing contracts cause of action against all defendants. Again. Now I know there are people out there who say there were no evidence of the contracts. Actually, in the pleading, in the first complaint, the initial complaint and the first amended complaint and the second amended complaint, it very clearly lays out that every single con that announced Vic is an existing contract. It is. It lays out that the announcement of Vic at this convention is part of the performance of said contracts. The announcement itself is evidence of the manifestation of the agreement and performance thereof by one of the parties. The announcement of the cancellation is canceling the existing contract. And now you can disagree legally that is sufficient to establish a contract or a revocation or a cancellation or a breach. You can argue that. You absolutely can. But what you can't argue is that it lays out a prima facie case for the existence of the contracts if you read the pleadings. That's it. And this was attempted to be raised at the hearing. Chup didn't really like this argument, and I think he wasn't understanding what was being said, but it's the practice, it's in the contracts, but it's most importantly, it's stated in the pleadings that once a con announces someone, that shows that they have entered into the agreement. That announcement is not the manifestation necessarily of the agreement in and of itself, but it is the broadcast of an existing agreement to the world. Cons don't typically, maybe some cons do, but cons don't typically announce someone until there is an agreement on the terms. That's just how it goes. And more importantly, that's what's stated in the pleadings. So there's your clear and specific evidence of, again, the existence of contracts, something Chup was very hung up on. Now, not to mention the fact that we have Slatosh in text message to Ron Toye saying that there was a contract on the books right there. So again, we have these things. I can't just cancel them. I've got a contract. Well, this is going to happen. This is going to happen. This is going to happen. I mean, we have it. You don't have to like it. You could say that it's not sufficient for a complete TI case, but saying it's not sufficient for prima facie, very, very, very iffy. And of course, on appeal, that's one of the things they're going to be bringing up. This stuff is in the record. It's in the pleadings from day one. It's not a last minute addition. This was there the entire time. And it remains uncontroverted. And they don't get to controvert the prima facie evidence either. So it's, again, this is weird stuff for the court to say isn't there. Now the TI with business relations, TI with business relations is a little bit different because part of that is relying, I believe, on Chris Slatosh's affidavit that he was going to bring him back and that they encouraged him not to bring him back for future conventions and stuff like that. And then the rational inference is that there would be other conventions that would have invited Vic that didn't. And that's stated, but I will suggest that this one is a little bit tougher for Vic, especially if you throw out the Slatosh affidavit. But the existing contracts, that's all in there. But interestingly, there are elements, actually, there are, I believe, all of the elements of this one in those text messages, which were included prior to the second amended petition from Ron Toye, which state, Monica's agent is going to call the other conventions that may be hosting Vic and have her tell them blah, 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 and tell them the same thing, right? I'm paraphrasing, but that's in there. That alone, that statement alone might be sufficient with the prospective business relations because they had a reason to assume that a business relationship would manifest, that a contract could exist in the future and intended to interfere with it. And we can rationally infer that they did interfere with it because they said they were going to. And it's, again, at this point, it's prima facie. So anyway, this one, existing contracts, definite question mark. Prospective business relations, less of a question mark, but still a question mark. Those text messages, I'm telling you, are brutal. Civil conspiracy. Plaintiff is alleged in his petition that defendants conspired and acted in concert to defame Vic unlawfully or alternatively lawfully by unlawful means, interfere with his existing contracts, and unlawfully or alternatively lawfully or by unlawful means interfere with his prospective business relations, and each knowingly assisted and participated in the other's actions. That's a quote. He doesn't cite where that quote is from, but I'm guessing, in his petition, he doesn't cite to which petition he's talking about or what paragraph. So good job, Chup, not providing that citation. Again, this is just poor legal writing from the judge, which is a shame. Real quick, Dustin Fritz Farr says, in the end, if Vic loses upon appeal, we still won the biggest battle. Funimation has lost subscriptions, have massive amounts of egg on their face, and other defendants have been dragged just as much as Vic. Attrition was won. Yeah, and we'll see how that attrition affects those other defendants going forward. That'll be very interesting. Okay, so the underlying cause of action had been dismissed by this order under the TCPA. Court finds that plaintiff have failed to establish by clear and specific evidence a prima facie case for each element of his civil conspiracy cause of action against any and all defendants. Again, I think this is incorrect. Now, for every element, maybe that's true, but he says each element. Each element. So he's saying in this ruling that in all of the pleadings, in all of the motion paperwork, in all of the affidavits that were considered, that there isn't any clear and specific evidence of any element of any claim. That's what he says. And I'm not sure Chup believes that. I'm not sure Chup believes that at all. I think Chup might mean he didn't provide prima facie case for every element of every claim, but he didn't write that, and he didn't specifically delineate which elements were lacking. So instead, he wrote it in a way that says that no prima facie evidence of any element of any claim exists in any of the filings, in any of the hearing documentation. That's absurd. That's an absurd statement. And again, it's an appeal point. Now, appeals are done de novo, so they will go through and review the entire record as well as the appeal paperwork that comes in. So Ty and his team will have they will have a job of very crisp legal appellate writing ahead of them. We won't know what that looks like until they go ahead and produce it. If they get to appeal, right? That's up to Vic. But let's see. Finally, vicarious liability. This has an interesting thing too. Vicarious liability claims against defendant Funimation relate to cause of action and conduct by defendants Markey, Rial, and Toye that have been dismissed by this order under the TCPA. The court finds that defendants have shown by a preponderance of the evidence that defendants Markey, Rial, and Toye were independent contractors at all times while associated with defendant Funimation. So that's interesting. I guess Ron Toye is an independent contractor working for Funimation. So very, very cool. Ron, maybe you want to sue them for breach of contract for never paying you or whatever. The court additionally finds that plaintiff has failed to establish by clear and specific evidence a prima facie case for each element of his vicarious liability claim against defendant Funimation. So there you go. This is Chup's maybe strongest argument. I'm not sure if vicarious liability existed. I don't think he addresses their agency argument. They just address the employment argument. So that's frustrating, I guess. The judge just left out that part. I believe that's in the filings, that they were either employees or agents, which are two different things. Agency and employment are different. So, he just didn't rule on that at all. So that's cool. Therefore, the court grants the TCPA motions. Plaintiff Victor Mignogna's claims against defendant Funimation, Markey, Rial, and Toye are thus dismissed with prejudice. court retains jurisdiction. So the defendants may submit evidence and briefing in support of an award of attorney's fees, costs, and other expenses incurred in defending the action, an appropriate sanction pursuant to Texas Civil Practice and Remedies Code number section 27.009. Defendants shall file their request for fees, costs, expenses, and appropriate sanctions within 30 days of this order, signed on October 4th, 2019. So there you go. That is the ruling. It's a mess. It's a mess. You know, but yeah. I don't know what more to say about it. It's a mess, and that's what appeals are for. How's that? That's what the appeals process is for. So, yeah. Well, I don't know what else to say, guys. There's the ruling. You've heard from Ty. It's up to Vic whether or not he files the appeal. I think he has a strong case for an appeal. But that's me. So. It's a frustrating day, even though it was the expected outcome, right? It's frustrating. I talked about it yesterday. This is the likely outcome. I said it would probably come today. I didn't think Judge Chupp would wait until Monday because I don't think he wanted to risk that 31 day or 32 day, whatever it ended up being, issue with ruling late on the TCPA and that being an appeal point. But I think he left just about every other appeal point that he could possibly muster in the document. And these are things that could have been remedied. Now, district court orders are often not super specific. It's not uncommon to get a vaguely worded order or an order that's missing some things. But, you know, that's... this one is particularly bad, in my opinion. It's just lacking, and it's a complex case with parties that have this isn't like, you know, this isn't some small little issue, right? This isn't a $10,000 rent dispute or something like that, like a commercial rent dispute. This isn't some car accident that doesn't need a fleshed out filing. Like these are complex issues, and there's a lot. But anyway, yeah. So I guess that's that. I don't know what else to say about this ruling. You know, we'll have to see what they decide to do. I think they should appeal it. I think that's the right move. I think that's the obvious move. But you're always dealing with a person at the end of the day, and maybe that person wants to appeal it, and maybe they don't. So we'll see. You guys have been wildly supportive of Vic, and that for that I commend you and credit you for everything that he's been able to do. So we'll see how it goes going forward. I would love to know the answer. Yeah. So anyway, I guess what I'm gonna do now is go ahead and I'll get to the reading of the rest of the chats. There's a whole bunch of them, and we'll close out the stream after that. So if you are someone who leaves for the reading of the chat, thank you for watching. If you're one of the hostile people in the chat, thank you for watching too. It doesn't bother me that you disagree. That's fine. You should spam less so you can just say what you want to say. You don't have to spam it. If you just say stuff that's negative, you're not going to get suspended or timed out or whatever. But if you spam it, you know, my mods will knock it down. So just some friendly advice for future streams. So as to Twitch, I don't know. I don't know if we'll do Twitch tonight. I think so. I'm really, really tired. I had a long night last night and an unexpected early morning today. So I really want to do Twitch, but I think I'm going to say no. How's that? I know that sucks for people who like the Twitch stream. I'm going to say no because I need a little more sleep than I got last night going into tomorrow. There should be some streams this weekend, both on Twitch and YouTube. My intern will announce them as those times are sorted out. I believe we'll have some guests. It will probably not be revolving around the Vic topic. So we'll be talking about some different things. But yeah, so if you are leaving now, thanks for joining me. And we will talk very, very soon. And yeah, I guess have a good night. Have a good night to those who are going to leave. And for the rest of you, let's get into this. Get into these chats here. Let's start with Justice. Shall we? PlayStation Lab, I do gaming videos. I do them on Twitch. Okay, we've got K. It says, great idea to keep judges from letting stuff like this happen. Judges pay costs for appeals out of their own pocket, or appeal to judges pay costs for appeals out of their own pocket. Maybe then Chup would have given a poop. Well, but judges get appealed all the time, whether or not they're correct. So it's the right sentiment, but it's maybe they would sanction a judge for a particularly bad decision. But I don't know that occurred here. Again, the ruling is worded very poorly. The ruling is written poorly, but I think ultimately the ruling isn't particularly egregious. Outside of the writing of it, I disagree with it absolutely, but it's not like he said that the plaintiff needs to go die or something like that. So Arctic oh wait, we read that one. TLJ Screwjob says, Ty, when your own client Vic Mignogna asks Sam Johnson, Markey's lawyer, what's the context of these tweets? Why didn't you include the context prior to the hearing? Apparently, since they weren't in evidence, now you can't use them. Law Kiwis. Well, I don't know what the strategic choice of not including the context is prior to the hearing, but they don't necessarily need to do that. They don't necessarily need to add the context of the tweets, especially with how Twitter works, because it's prima facie. So whether would the context support the prima facie? Maybe, but what's the context of Jamie Markey making the tweet talking about her entire her hair pulling story? Because I think she just made that tweet. That tweet is, you know, irrespective of context. The context of the other tweets, aren't they? I think they were related to the hair pulling story. I don't know, but the way Twitter works, what context do you provide? I guess you provide the one that goes for you. I don't know, but I don't know that that many attorneys are familiar with how you provide appropriate context on Twitter with the way the conversation sprawls. So I don't know. Maybe that's an error. Maybe not. I'm not sure. But we'll have to see. The question, I guess, is how much time and bandwidth do you have, and did they think that was necessary? They must not have thought it was necessary to make a prima facie showing. But we'll go. Hellsnake says round 2 is coming. Kick Vic B words. We're not dead yet. Rise up. Also, Nick, screw Twitter. It's a trash fire. And hi, Ty. TLJ Screwjob says, so Nick, would Ty be able to use the fact that nobody has ever said Ron Toya is an independent contractor of Funimation as evidence of Chup's F-up? Like Chup didn't even try to read anything if he thinks that. I don't know that they would argue against it. I don't know that they would argue against it at all. Maybe they would, maybe they wouldn't. That's again, that's a strategy question that I know Ty wouldn't answer on the stream, but I'm sure they'll be considering how to use that. I just don't know what their answer will be. Mercenary X says, hey, Nick, I know I had a bad feeling about Chup, but did Chup actually my properly or not? That's dismissed everything because he realized how badly he screwed up. I think the best people that way also heard about the Twitter nuke. Okay, so I think what you're saying is, did he basically, is this ruling and him realizing how badly he screwed up and just saying, I want to get rid of it, and we'll see if the appeals court wants to deal with it? Maybe. I don't know. I'm not in his head. Schwazoom says, Ty may be bound to not insult the judge, but not I. Judge Chup is a clown, only has his position by running unopposed in his district and collects writs of mandamus like Nick collects ethics violation complaints. Kiwi Farm has lists of his failures in this. Kay says, please explain that weird video of you burping in the shower. Also show tattoo. No and no. Actually, I can explain the video of me burping in the shower. I was mocking Maddox. That was the whole point of that video. Was a mockery of Maddox, and you'd have to kind of research why that is a mockery of Maddox on your own. But there you go. Show tattoo, no thanks. Schwazoom says, Chup didn't accept Ty's evidence, rejected entire petitions with no stated reason, selectively accepted the withdrawal but not the same day filing, used wrong evidentiary standards, accused Ty of sneaking evidence in a filing that did not add new evidence. Yep. That's that. Kay says, I once saw T. Greg talking about how proud of his law children he was. I asked him about his real child and he blocked me. Kay says, if Ty is admitting that he failed, does that mean he'll be covering appeal costs out of his own pocket? That's between him and Vic. I don't know. TLJ Screwjob says, Ty, one of the law Kiwis is saying that you should hire an appellate specialist since you'd have emotions running high when the appeals court only cares about the law. Is this something you would consider doing if Vic was willing to bring on more? Again, that's going to be between Vic and Ty on what they want to do there. But, Ty's firm handles appeals decisions as well. And, that'll be a decision to make between them and their client. And again, that's something that he wouldn't be able to answer on stream either. TLJ Screwjob says, Ty, if this gets back in thanks to appeals, I want to hear them admit they wanted Vic to Minecraft himself. I want these snakes to admit to the world that they wanted someone they called friend for 20 years dead simply because they were jealous. Not Matthew Connor said, you put the boomer in boomerang. No matter how you go, you always come back. Love the show. Keeps me going working overnights. Hey, thanks, buddy. Hellsnake says, Hi, Kick Vic Trash. Hope you like the stream and have a shit day. Bad Dragonite says, wait, Nick, no. Don't watch The Joker. It might turn you into a mass shooter. You'll end up going to the lake looking for your guns and everything. Oh, man, I better stay away. Good thing I don't get to the theater very often. Sigma Zero says, such a dark day. Just when everybody thought something wonderful would happen, Black man stopped Joker from saying the N-word on the internet despite hundreds of N-word passes received. Truly the darkest timeline. Commissar Fuqlaw says, please tell Mad Black Cuck to stop trying to steal viewers for his worthless channel. Also, MBC, take your spurgs in the chat with you. So, there you go. That's an opinion on Mad Black. Fluffy Side Up says, hey, Nick, is the fact that Chup never ruled on Ty's motion to compel discovery very prejudicial to Vic? Well, I don't know that they set a hearing on that motion to compel discovery, so no. Although he did kind of raise it in the hearing, and the judge said, he said we weren't sure if we could deal on that with the discovery stay in place, so that might be preserved for appeal. I don't know. Maybe. Also, look up SNS emergency training versus Elliott 170268 and see if that could help Ty on appeal. Supreme Court ruling on TCPA regarding prima facie. Okay. Michael Rule says, greetings from the Netherlands. Question, what does it take these days for a judge to acknowledge that damage has been done? I don't know. Where Tiger Ray says, how would appeal affect the statute of limitations on Igor, and Renfield? The statute of limitations is still running on any statements that they may have made or any acts they may have done. DLJ Screwjob says, so can we say that Chup was bribed by fat chicks and horses? You can say it. I don't have any evidence of it. Mike Mysterio 13 says, I sent you an email earlier. Kind of girlfriend got in trouble for being on the phone at work. Punishment was suspension without pay and reduced wages for today's shift. Sounded highly suspicious and illegal. Maybe. I don't know. I did see that email. I might have to refer you to an employment lawyer in your state. So I'll see what I can do there. Talenseer says, it sounds like Judge Shupp went full 40K Inquisitor on this one. A plea of innocence is a guilty of wasting my time. Guilty. Tacos for hire for tacos says, we lost again, boys. Ready the vodka and F's in chat. The Anime Collector says, don't forget to plug Cody's Indiegogo for Imp Story. Imp Story. Oh, dang it. I forgot to plug the mug. I'll put it up while we read some more of these. 1 second. Here's the, is it? Oh my goodness. Let's see if we can find this particular one. Here we go. Oh, go away. Oh my gosh. Here's this. I'll put it up. Why can I not do anything correct? Here we go. Don't answer that. Don't answer that. There we go. This is the West Nile Best Nile mug. So this is the one with the writing on the back where it says West Nile Best Nile. And we've got the mosquito sucking on the lemon. So that's on the Teespring store that you can find linked in the description. And there should be a scrolling ticker. I don't know if the mug is on the scrolling ticker, but you can get to it that way below your video as well. So just in case. I was supposed to plug this, but there it is if you want to pick one up, go ahead. You've been grifted. You've been sufficiently grifted. All right. All right. Here we go. But yes, Cody has an Indiegogo for Imp Story. So you go look up Imp Story on Indiegogo. That is Cody Bayer. He's been on stream. He is Anime Outsiders. Or he is from Anime Outsiders. I shouldn't say he is the total of Anime Outsiders. The Geek Conservative says late 75% of the time, gay 100% of the time. Joni Baloney says late and sunburned, ADL created by pedophiles. Ninja Work 111 says, did you see the Joker movie? If so, did anyone rise up? I did not. The infamous GS says, according to Animat, you and Ty are the biggest help for Kick Vic and your GoFundMe is a scam. Care to rip him a new one? No, I don't even know who he is. So no, I don't care about Animat. Adam D says, just sent Vic a contribution. Evil must be confronted. Hope you all do the same as much as you can. That's from Adam D. Next, we've got Adriano Abreu says, having followed the case from beginning and read all the filings, it's sad that the defense was allowed to lie and misrepresent so much in the filings. Yes. Yes. Wing012 says, so how much does Vic have to pay now? Well, we won't know. We won't know for a while. Jay Fraser 360 says, hey, Ty, I just want to say you're awesome. Hey, Nick, are there any updates on this BoomerCon? They will be coming, but they're going to be coming as things actually get solidified. So will there be any con sluts asking for a future broke lawyer still looking for evidence? Possibly. No one important says, today I learned that after Monica spinned herself as a champion of victims, that she's either truly evil and or don't know what victim means. Tacos for hire for taco says, season 2 confirmed, boys. Diablo says, gentle boomers, I raise a glass to our future happiness. We may have taken a blow, but I know we'll take the case. Wing012 says, F turgid tyrant. So there you go. Master Knight DH says, I made a GoFundMe donation and comment. Obviously, the YouTube video would take its time to watch and everything, but otherwise, I'm up for hearing your take. Hey, thanks, buddy. Obscure Anime Guy says, finding a photo of Ty standing is like looking for a photographic evidence of Bigfoot. He never stands. He only sits down. Moist John says, do you think that Mark Zaid, now being the whistleblower's lawyer, will sunset his career like Avenatti on the Drumpf is finished train? Remains to be seen. Mark Zaid, one thing that he has does seem to have a very good career at is representing people against the United States government. So who knows? Maybe he'll do a great job. Sergeant McSalty says, even if Vic was guilty or the case ends up being a total loss, Ty would be like Jim Donovan, having still stood up and fought for justice. P.S. Bridge of Spies equals best legal drama. Changed my mind. I haven't seen it, so I'm not going to try. From Eggman says, you skipped my super chat. Well, I didn't skip it, I don't think. Did I? Did I end up skipping your super chat? Or did I just not get to it by the time you sent it? I think I read it. No, I read that one. Sorry, I just hadn't gotten to it when you sent that update. Okay, where did we go? Oh my goodness, there we go. Captain Awesome says, I feel like Ty showed up to TCPA expecting a game of checkers and Chup decided it was 3D chess instead. Xander's Rant says, Ty, have you played Dungeons & Dragons 5th edition? Rip Nick Rekieta's liver. I think he has, but I don't know. Howling Warwolf says, I think I read on Kiwi Farms that Chris Chan was I Stand with Vic. Maybe he will perform a Curse Yameha on Monica and Soye. Ty Brunner says, Nick, why you no give Ty more gum to kick arse? Lol. Cuz he doesn't deserve the gum. Oh, wait. Zypher Warrior says, page 4 of Texas Law Review shows it is for the new law. Oh, no. Again, I'll have to confirm that applies to that section, but that'd be pretty funny. Ricky1186 says, hey, Nick, there's a defamation case seemingly started in Australia where a billionaire tycoon is suing a YouTuber for defamation and damages. Ooh, very exciting. Nathan Kish says, my theory, Chup realized he dismissed things he shouldn't have and dismissed it all so it could be tried in one go. I could be wrong. I'm no lawyer. We won't know. We'll never know what was in Chup's head. Character Holding says, do you think the court system could be improved? Also, without it, how soon will we kill each other? It could always be improved. How soon will we kill each other? Immediately. It won't take long at all. Patrick H says, remember the words of Sam Hyde, peace be upon him. These people want you broke, dead, your kids raped and brainwashed, and they think it's funny. Good quote from Sam Hyde. Also true. They do want that. Felipe M says, hey, Nick, here you go to get to 300,000. It's just a couple of bucks, but let worry the stupid kick Vic. Keep the fight, guys. We got your back. Vic has to appeal. This is bigger than just him. It's about due process. I agree, but it's his decision. Texan83 says, I doubt Vic wants to make it public who he is getting work from so that people who like to Twitter mob can't Twitter mob against him again. Yeah, I don't know who Vic is getting work from. I just told you someone reached out to me to see how they could help Vic get more work. That's all I said. I don't know who Vic would be getting work from. Oh, I think someone was saying that must have been in response to the person asking if he was still working for Viz or Sentai or whatever. No idea. Chris Radford says, I got blocked today just simply saying don't claim victory till appeals happen. Why are the kicks softer than 10-ply? No idea. Bad Vibe says, you should watch Sound and Fury on Netflix. Modern, think 42-minute music video, heavy metal style. The Pie Baker says, Australian woman accent. AOC ate my baby. It's not Australian woman at all. Jonathan Updaye says, Nick, were you there when Horus slew the Emperor? Or were you there when Horus slew the Emperor? No, I was not. Douglas 3368 says, Nick and Mr. Beard, are there going to be another round of lawsuits? I don't know. We'll have to see. Wing012 says, has Renfield, Igor, and Iago been identified yet? Not to my knowledge. John West says, will you still go after Iago and Igor? That'll be up to, that's up to Ty and Vic. They can't answer. He can't answer that question on stream, guys. P sure says, thank you to Ty and his team for being class acts throughout this whole ordeal. We'll be donating again to the GoFundMe War Chest after the stream. Please know we will continue to support you all the way. Cool Tactic says, I missed the beginning of the stream. Was the case dismissed or what? Give me a quick rundown for people just tuning in. Yes, the case was currently dismissed, and now it is up to Vic whether or not he appeals it. Marius Van says, life advice. If you feel a compulsion to argue with people on Twitter, delete Twitter. Probably stay away from casinos and alcohol. Gethrolkin says, Jamie, Ron, and Monica will fade into obscurity after the case is finally over, and Vic will only keep getting people lining up to meet him. Rich Meister 84 says, thoughts/plan to cover Trump impeachment inquiry. Yeah, I do plan on covering it. We'll see how it goes. Thoughts? It's a very risky move by the Democrats to impeach the sitting president. It's a very risky move, actually. So, but we all knew it was kind of coming. They've just been building up and building up for it for the past 3 years. I guess it had to happen at some point. Nathan Kish says the fans will continue to donate to the GoFundMe out of love for Vic. Who's paying Moronica's legal fees? Who loves them enough to donate? No one, it seems. Basement Troll Production says, hypothetical question. Let's say Monica, Jamie, Ron get emboldened and start running their mouths again. The ruling gets reversed on appeals. Can their new comments now be used against them? No, they would be new claims. I mean, they may be able to be used against them for, some sort of bad faith or something like that, but not as evidence in the existing claims. Because the existing claims stop when the filing occurred. Because otherwise it would start a new TCPA process. Thomas Chilemi says, where is Kamehacon owner, the alleged text? He should alone prove TI. I find it very strange and incompetent to not have the only witness Vic had. No, they did have that. Kamehacon owner and the alleged text. The texts were included in there, and the Kamehacon owner provided a affidavit and an unsworn declaration. So, Armchair Warlord says, can the court even make fact findings at TCPA? Well, it asks for clear and specific evidence. Certainly on the preponderance of evidence claims, there should be findings of fact. Certainly on those. On the conclusions of law claim, there should be those, or I guess they would have to say for their findings of fact that they didn't have any fact finding. They didn't have any facts to support it. But I think they should go element by element if they're going to do it. At least in this case, because there were certainly facts provided. But yeah, I don't know. Mario Carter 13 says, flashback to failed math test for not showing work. Kalinka Pavlova says, some bum tried saying to me that Vic needed to receive special damages in order to prove damages occurred for prima facie. Thoughts? That's incorrect. Austin Heartless says, armored mosquito tortiously interfered with my prospective contacts with consulates. Nylock 7 says, the second part of my question about AIs in the courtroom was AIs assisting counsel and judges like Watson being able to bring up any requested information, not necessarily replacing them. Oh. I don't know. Maybe we'll have to see. It all depends. Court is very slow at adopting technology, so outside of a radical shift, I don't see that happening anytime soon. Curious Items Inside says, since the TCPA became a mini trial in a sense, can that be brought up in the appeal that Time may file? Yes. Karme Taika says, is it timely now to ask you to review my Second Amendment case? Sure. Kazma says, so given the ruling, what do you think Chup's thought process on the case was? I don't mean just the dismissals today, though. I mean the whole thing. I don't know. I really don't want to try and get into Chup's head because I don't understand how he dealt with some of these things. I guess the closest I can say is it kind of looked like he really wanted to get the case off of his docket. Cloudfire 181 says, Nick, I tried to email you before but never got a reply via email. What's the best way to contact you? Email me again. Valhalla 4413 says, I refuse to believe Monica wants to be safe until she ditches the worm of a man she's engaged to. It's only a matter of time until he turns on her as well. Victor Phantasm says, Nick, I'm a dumb and not to shill, but I use templates from Law Depot to make contracts. Will they hold in court? Also, when will you have Jim? I don't know. I haven't talked to Jim in a long time, but I can't comment on your Law Depot contracts. It's state specific and industry specific and contract specific. It's going to be different for each one, whether or not it's good enough. Hard to say. Rogue says, always remember, I stand with Vic would not exist had Kick Vic never formed firing the first rounds. Zypher Warrior says, page 4 of Texas Law Review shows it's for a new law. Carme Taika says, Nick Fuentes, Rekieta crossover stream when? I don't know. I've never really talked to Nick. He was on the kill stream when I was on once, but I didn't spend much time talking to him. Rolana 1 says, does this being dismissed with prejudice make it any harder to appeal? No, it actually makes it easier to appeal. So, there you go, guys. I think that's everything. That's what I've got for you tonight. So I will, I'm going to close it out. I am really, really tired. I'm going to go take a rest. Like I said, no Twitch tonight, but there should be both Twitch and YouTube streams over the weekend. The YouTube streams will be announced by my intern when I set them up and communicate that with my intern. So check out at Law Archive for updates on the YouTube channel. In the meanwhile, while I appeal my account suspension with Twitter. So, all right, guys. Thanks for hanging out tonight. I will see you very soon. Peace. Peace. Oh, wait. Here, have some music. Peace.
Oh, he drinks a fair bit, but you realize that it just helps get his noggin jogging along. With his glass by his side and his kids asleep tight, we'll hear some lawsplaining tonight. With his microphone muted, we'll laugh at this boomer until he explains it's all part of the plan. Watch his face become redder as he becomes meta, raging at idiots from Twitterland. From the white shores of Maine to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we have now. Oh, his lady is fair, and she handles herself with the grace of one who has borne many children. As the wife of a lawman, she makes sure that he has the time and the place to provide for them there. So pour out an odd bag of Balmore and Lafroig. The spirits flow as the ones who get unemployed. So pour out a glass for the tea post on Twitter as we hear lawsplaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law better than Nick. So pour out a glass for the ones who have passed to make the law what we are now. Oh, the guests are all plentiful, from Doug T to Drexel. They bring their perspective and spice to the mix. But the reason we're here and the one that we cheer is the one who is showcasing us his career. Get unemployed, so pour out a glass for the tea post on Twitter as we hear lawsplaining tonight. From the white shores of Nan to the hills of Glenlivet, there's no one who explains the law